started.
Should you do the opening first?
Yes.
You need it. Morning, I'm Ed David, and on behalf of my fellow commissioners, I welcome you to this meeting of the Maine Human Rights Commission. Before we proceed with the business of today, I am asking each of you who may have an electronic device, cell phone, pager, etc., to ensure that they are silenced now. I am showing you by example, silence. And we have additional agendas, including the consent agenda available in the back of the room. The consent agenda is a listing of cases in which no written arguments were made to the commission in the allotted period. The commission has voted on those cases and they will not be considered further today. The remaining cases on the agenda today are coming before the commission to determine if reasonable grounds exist to believe that unlawful discrimination has occurred. Commissioners have received and reviewed investigators' reports and any written submissions submitted within the allotted time. No new information or any written materials will be accepted today. Cases will be called in order on the accepted agenda. As I call each case, the party who has submitted a written argument will be called to the podium to provide the most relevant arguments to the case. Time is limited to 10 minutes. Time may be reserved to rebut closing arguments, but the time of 10 minutes may not be exceeded. Procedural rules of the commission specify that your arguments may address only one: relevant factual areas, relevant omissions from the reported facts submitted during the investigation, or 3 relevant issues and questions concerning interpretation of law. The commission allows parties who do not disagree with the investigator's report to rebut comments made by the opposing party. Please be advised that commissioners may ask questions. I will ask that you introduce yourself. Another page. Well, there it is. Ask that you introduce yourself when you come to the podium. With that, call the meeting to order. Okay.
Yes, great. So could I first have a motion to adopt the agenda and consent agenda?
So second.
For our remote participation policy, I will ask the commissioners to indicate their vote both verbally and visually. So if you are in favor of adopting the agenda and consent agenda, you will vote yes. Commissioner David.
Yes.
Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders. Yes. Commissioner O'Brien. Yes. I'm not used to having you there. All right, and then I gave you all the July minutes this time, right?
I think so.
Great, okay. So then I would like a motion to approve the July minutes.
So second.
Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders.
Yes.
So today's a quarterly meeting. Have many reports for you. For the first personnel, we have hired our new investigator. She starts today. She's at orientation as we speak. Hopefully she found it. And it's up in the class building. And they always say, just come to the 3rd floor. And I'm like, I hope somebody will be there waiting for you. So she's at orientation. I have put both of Jane's reports on first so that Jane can go downstairs and meet her. That's why we're a little out of order today. But we're very excited. We are now almost fully staffed. We will have we'll hire one more investigator sometime in the next 4 to 6 months, and then nobody is allowed to leave. Right. And we will have 15 people working in the commission for maybe the first time ever. For compliance, you have a memo reporting to be, actually it doesn't report to be from anybody, it's from Jane. We have 3 cases in active conciliation, 2 unsuccessful conciliations, 3 successful conciliations. I will ask you to include those agreements. And we also have 2 cases that have finished their agreements, they're done monitoring them, and so we will ask you to dismiss those. Why don't I do that now while I remember? So I would need a motion to dismiss E19-0323 and E19-0390.
So moved.
Well, almost. And to approve the agreements in H23-0461, PA 220080 and P 220125.
So moved.
Commissioner Sanders.
Second.
All right, if you vote yes, you are in favor of all of those. Commissioner David.
Yes.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
Yes.
Commissioner Sanders.
Yes.
Taken care of. 4 new charges. We have 33 new complaints filed in July, 19 dismissals. That includes 11 where I sent an administrative dismissal letter, 4 right to sues, 2 cases that settled successfully through our mediation program, 1 that settled privately, and 1 that was a withdrawal with no benefits, for a total of about $86,000 to complainants. I'll ask that we take litigation in executive session. You have a memo on pending inventory. We have 736 pending charges with an average case age of 315 days. I know the report that screenshot from the EOC says there are 737 total pending. One of those is an intake that the EOC is still processing and decided to count as. Why they do that, but they do.
How that compares?
Pretty,
That's
yeah,
what it's-
yeah, that's pretty typical, yeah. Yeah, we usually have somewhere between 600 and 800 cases open at a time, and they're usually a little less than usual on average. Training and outreach, you have that memo. We have been very busy, and you were all listed on here because you all attended the training with Mandy at our June 10th meeting, and Commissioner O'Brien was at the Fair Housing Summit. I'll give you more information on this as we develop it, but we are planning another summit, just a general human rights summit in January, when you can all come and get your harassment and discrimination and ethics credits at that one too.
Did we get our credits for this last one?
You should have, yes. I will double check with Carrie about that. You're pretty good about submitting that paperwork, so. If you haven't seen them, that you might want to check with the board. Okay. And so we have the training and outreach, and Michael has given you a financial report that is legible, which is much nicer than the ones that I used to give you that I couldn't even understand. But if you have questions about that, Michael is here to answer them. And no new business other than that we are entering budget season with the legislature, and we'll be submitting 3 pretty minor bills this session. 1 to fix the statutory things we tried to fix last time, 1 to change Barbara's position to a major policy influencing position, and 1 to try to get our mediators covered under the Maine Tort Claims Act for the purposes of mediation.
I do have one, it's a very small question about the budget, under special revenue funds. Yeah, under publications, we charge for publications? Like that go around to businesses, or where does that come? Okay.
No.
Right.
Sorry, I'm just publications. That's how much we have in our publication fund that we, and that's how much we spend on getting those things printed so we can give them
Okay,
to.
okay.
No, we don't charge for our.
yeah.
No, the only thing that we charge for is when we do offer scale leaves, we usually charge for those. And I feel like we charge a pretty reasonable rate, given that the last time we did CLEs at the Fair Housing Summit, we charged $150 for almost 6 hours of CLE credits. So, no, and we are not in the business of making money most of the time. Yeah. Any questions about any of those reports? Great. We have 3 minutes. Shall we be in recess for?
Sure. We'll be in recess until 8:45. I'll call the meeting to order. The cases for hearing on the agenda. The first case is E23-0064, Jake Kulaw versus Portland Public Schools. The recommendation is for finding of no reasonable grounds. Therefore, we would hear from complainant.
And just in line with our confidentiality requirements, please do not use the names of any person or entity or organization that is not a party to the case. So in this case, the only names we should be hearing are Mr. Kulaw's and Portland Public School. Is there somebody here for Mr. Kulaw?
No, I'm just here for myself.
Are you Mr. Kulaw? Okay, great. This is your opportunity to present.
Good morning, dear Director Kit Thomas and Crossman and distinguished commissioners. Thank you for this opportunity to speak directly to you about my case. I'm here to detail to you how the harassment that I endured while employed at Portland Public Schools impacted me. Investigator O'Reilly, should I not say her name?
No, you can say the investigator.
Okay.
And I just want to let you know I have started the 10-minute timer.
All right, yep. Asserted there were no reasonable grounds for my complaint and that Portland Public Schools do not discriminate against me based on my gender identity, and that this complaint should be dismissed. I emphatically disagree. My classroom management and my being harassed based on my gender identity are two separate issues, and yet co-principal one conflated the two. My classroom management should never have been introduced as part of this complaint. I did not need help with my classroom management skills. I needed the administration to address that I was being repeatedly harassed based on my gender identity, which is a protected class, and that harassment of a member of this protected class is illegal. Furthermore, I was never made aware that this conversation with co-principal one was to discuss classroom management. Also of note, I have never been made aware of this issue prior to my asking for support from the administration in regards to being repeatedly harassed by a small group of students. I had a union rep with me when co-principal one said, Jake, freshmen are meaning cruel. If you can't deal with it, then perhaps you should consider your options, and we will agree to support you if you agree to coaching by me. The union rep provided a written statement to Investigator O'Reilly. Why is this never mentioned? It is relevant information and corroborates my statements. Co-principal one also blatantly misrepresented the truth in the hearing on March 12, 2024, stating that she witnessed me yelling and screaming at students in my health class. And then in a follow-up informal conversation, she stated that I was having a bad day. This supposed conversation never took place. Co-principal two also misrepresented the truth, stating that I never asked him to reassign me to different duties for the remainder of the semester in December 2022, just before winter vacation. In co-principal two's defense, Investigator O'Reilly never gave him that specific context to help him remember this conversation. Instead, she asked co-principal two if he said to me, you can't let the kids know that they won and hang in there. She left out relevant information. The gaslighting going on only added to my stress and anxiety. Investigator O'Reilly also states in a report, that 14-year-old high school students need different action and language versus adult harassment, and that using harassment wasn't appropriate. Again, not true. If they're old enough to call me a he/she, a fucking bitch, and misgender me on a regular basis, then they are old enough to hear that what they were doing was harassment based on my gender identity. As far as hostile work environments not being established, if being harassed for nearly 3 months, creating anxiety and hypervigilance on my part does not constitute a hostile work environment, then I don't know what does. The students were not removed immediately, and this process took several weeks. I was being targeted, and the administration didn't support me. I wasn't asked if I was okay. I was dismissed, and even worse, was made to believe it was my fault. The harassment that was allowed to continue had a deep impact on me. I couldn't sleep. It was hard to focus. Something inside of me broke, and no one understood this, even as I repeatedly told the administration that this was happening. I filed an ACAB-R, harassment and sexual harassment of school employees complaint, and that too is dismissed. However, that doesn't discount the reality of what was happening to me. I offered recommendations that included implicit bias training for all staff and students, an apology from co-principal one, all issues related to my concerns be addressed by co-principal two, as I never felt safe with co-principal one, and a district-wide professional development course on issues facing the 2S LGBTQIA+ community. I also emailed someone at HR and told him that I disagreed with several of the lawyer's findings. He never returned my email. Under the advice of my PCP and my therapist, as well as an MEA Uniserv director, it was strongly suggested that I resign my position. My PCP stated that stress and anxiety could possibly lead to another heart attack. The MEA and the PEA president also agreed that the harassment wasn't being taken seriously, and it would be in my best interest to resign, as they saw how the harassment was impacting me and saw that not much was being done to address my safety and my concerns. Let me state for the record that as an educator, I am open to feedback. This was never about my classroom management, at least it shouldn't have been. I have never experienced such utter dismissal of the harassment I was enduring. Co-principal one has never apologized or acknowledged that I was being harassed or the impact it was having on me. No responsibility was taken on their part. Perhaps Portland Public Schools met the legal standard for addressing the harassment in a timely and appropriate manner. If so, then perhaps the legal standard should be re-examined. The bar is way too low, and it allows the system to protect those who already hold power. They know exactly what they're doing. Administrators are required to take classes on legal issues. They know exactly how to game the system, force teachers who are hardworking, dedicated, and outspoken to eventually leave the profession or the district. Shouldn't be this easy, but it is. Fortunately, there are many exemplary administrators that do support their teachers. That wasn't the case with Portland Public Schools at my particular school. It says a lot when several teachers leave the district or choose to leave and teach at a different school in the district. I was reassigned to Portland High School for 1 year, and the leadership of the top supported teachers and also gave us feedback in a meaningful way. They truly wanted to help. This was not the case at where I was. The leadership instead gaslights and makes you feel like you're alone. They decide to support only certain teachers, not the ones who actually challenge some of their decisions and ask for accountability. Harassment is a serious issue, and Portland Public Schools chose to respond in a way that left me feeling alone, isolated, and fearful for my emotional safety. They were in no way prompt in their responses, and I have already stated they instead deflected and made me the problem. Legal standards versus justice. That's what's at stake here. They acknowledged that I was being harassed, that it's illegal and harmful. They took several weeks to remove students or respond, and they didn't even use the word harassment. They shielded themselves. Investigator O'Reilly took the position they weren't mature enough to be told what they were doing was harassment. This is an individual who works for the Maine Human Rights Commission. I didn't stand a chance. Systems are inherently powerful and have money and resources to make what they perceive as problems to go away. It's really sad. This means that another teacher who identifies as 2S LGBTQIA+ is at risk of facing the same harassment. Not okay. The main reason I filed a complaint with the Maine Human Rights Commission is because I didn't want anyone to have to endure the extreme harassment that I was forced to. They can walk away and never have to think about what they did. They are not being held accountable, and that makes me very sad and very disappointed. For my safety, I had to resign. I still suffer to this day, and my career, when I loved with all of my heart and soul, ended abruptly. More and more 2S LGBTQIA+ teachers are leaving the profession because they fear what happened to me will happen to them. What a loss for students, particularly 2S LGBTQIA+ students. It's a travesty. I will close with this. An excellent opportunity for educating students about harassment was missed. Portland Public Schools dropped the ball. They had an opportunity to address harassment and the harm that it caused. Instead, they blamed me and never held those students accountable. A one-day suspension is not adequate. An opportunity to educate the students and to have them listen to the harm they caused and to have an opportunity to make amends was missed. Imagine if the students were taken through a true restorative process, one where they could listen after they were educated on what harassment is and why it isn't tolerated, one where the rest of the class had an opportunity to share how the behavior of a few students impacted them without me present. I was never averse to a restorative process. However, it was executed poorly. Restorative processes take time and effort, not one or two conversations where we acknowledge what we appreciate about each other. One where I was asked if I was okay and told unequivocally that what was happening was wrong and I would be supported, and that Portland Public Schools does not tolerate harassment for any reason. This would have been more meaningful and relevant. Instead, justice was not served. Thank you for your time and for listening.
Mr. Gulak?
Oh, yeah, sorry.
That's okay. Any, yes, Commissioner questions, Commissioner Bryan, and then Commissioner Depp.
Good morning. I have a couple of questions, and I apologize if I missed it. But when were you hired? When did you start work?
September of 2018.
Oh, okay, so then you mentioned the 3 months that were really.
Yeah, just in that year.
Okay, so you hadn't had issues before?
Nope.
So just-
Never addressed by anybody.
So it was a particular group of
Yeah.
students that.
Yep.
Okay, and thank you. And the other question, one of the footnotes said that you claim students were coached to file the complaint in retaliation against you, retaliation for your arrest. And what would have been the basis for their complaint? And it wasn't supported. This says that claim was not supported.
It's just a feeling you have. I did eventually, a student did come forward, but I can't include that in this
Go with the echoes in the record.
Okay, okay.
So.
Can you, well, you can't, I can't. All right, okay.
I wasn't gonna force that student to come here and have to.
No,
do this. So,
no, that's not what I'm asking, what would have been, what would have been the basis for their complaint?
who's complaining? The students who,
Okay, complainant claimed that students were coached to file a complaint against him.
me,
Yeah, all right, in retaliation for your report of harassment in violation of the Human Rights Act and whistleblower. So why would they, what would be the basis of the complaint that they would have against you?
they were, well, that was also investigated and they were, it was found, nothing was found. They invited me back to work, but I just couldn't do it. But they claimed unsuccessfully that I was walking into the girls' bathroom,
Okay,
stuff like that, which is a typical transphobic
okay,
trope. So,
that's what.
yeah.
Thank you.
Yeah.
Yes, good morning.
Good morning.
So I'm trying to zero in on exactly what it is that you're claiming the school should have done, right? So reading the report, it says that certain things were done, right? The kids were suspended. And I understand you don't think the suspension was adequate, but they were suspended. There were these restorative justice sessions that ultimately they, these students were moved out of your class, right? So what I'm gathering, and I wanted to ask you directly, what I'm gathering is that you don't like the fact that the investigation took a long time, several weeks, should have been faster. Is that accurate?
Yeah.
Okay. This is sort of a sense that I have. You wanted these students to be told that this was harassment, right?
Correct.
You wanted the language used with these students to be stronger. Is that true?
Yes, correct.
Okay. What else were you looking for in terms of a process that you think would have been appropriate?
Well, a training, as I said before, for just on implicit bias, because I think that played a role here. And also, excuse me, also, a district-wide, we have professional development courses like that deal with race or poverty, things like that. So I suggested that perhaps there could be some kind of course taught for professional development. During it, I asked specifically before I even filed a complaint with the Maine Human Rights Commission that my communication in regards to this issue be with co-principal 2, because I just didn't feel safe with co-principal 1. And then she kept coming to my class. So I was like, I don't know, that was also in the ACABR report, which also I was told it was gonna take, a few weeks, and it was a couple of months, which is fine, right? Things happen, but I had to call a meeting where I asked the lawyer doing the investigation. I asked him if he had interviewed some of the people that I had given him names to, and he said no. I asked him why, and he said, well, because it was clear you were being harassed. But in his report, he never says anything about harassment. It just seems odd.
Clear you were being harassed by who?
Um,
You said it was clear you were being harassed.
by students.
Okay. I don't think there's any dispute. You were being
Yeah.
harassed by the students, right? I think the question for us is, how
And
did the
again,
school
look,
respond?
Again, as I said earlier, I think the ball was dropped. I don't want them suspended for 10 days. I'm not talking about punitive punishment. I'm saying the restorative process that occurred was kind of a joke, right? Where you say, oh, what do you appreciate about Mr. Kula? Mr. Kula, what do you appreciate? There's no discussion. Not once in any of these conversations were these students told unequivocally, are you aware that this is a form of harassment? Do you know what that means? Like, explain. Education. We're educators. That's our job, right? So to say they weren't mature enough, well, they were mature enough to harass me for months. You know, and so.
And if
that's
I
just
correct
sad.
it, the issue that you're having with all of this, right, is that for the restorative process, the inadequate suspension, in your view, was not really sufficient to deter this conduct going forward.
Correct.
Is that part of your?
Correct. The message those students got was it's okay to harass a teacher.
Thank you very much.
Just good morning.
Hi.
Thank you for coming. Quick follow-up to Commissioner Douglas's question. Would it have been adequate, in your opinion, for the school to expel?
Yes, I didn't want expulsion. I didn't want street measures. I wanted a true restorative process. I have some training in restorative processes, and I know how it's supposed to work. It's not, oh, hey, let's everybody hold hands and go kumbaya. That's exactly what happened, right? So, did they even investigate any other students while I initially had this complaint going? I don't know. I don't have the answer to that. My answer, I think, is no. Students who weren't involved. Was there a restorative process for that particular class without me there for them to say, hey, this is what we witnessed? No, I can tell you that never happened. Was the term harassment used? No, we've already established that. And was there an educational opportunity given to those kids to actually learn, like, hey, listen, this is why we don't do this. It's okay to have policies, and Portland Public Schools has tons of policies, but what happens when they're not addressed in an adequate manner? That's window dressing, right? That's window dressing and does nothing. Like, if you're gonna allow the type of harassment, I don't think anybody understood. And I kept saying, and one of the things I asked co-principal 2 was, I remember specifically going to him in December 2022 and saying, please take me out of this class. Please, I'm having a hard time. I'll substitute, I'll do office work. I will do anything you say. There was about 3 weeks left in the class. And his response was, no, you can't let the kids know you've won. Just hang in there, please.
So that would have been in your mind, and I understand you weren't looking for an expulsion.
No.
You were looking for, really deep, rich education.
Yes, exactly. I really believe that we do a disservice to students. They're mature enough, they know, and they need guidance, right? So I'm not for punishment, like, put the hammer down, no. I'm for, like, let's have a discussion about this and talk about what it is, and all that. And it's, I really think those students could have benefited so much more richly from a true restorative process where there was an actual process.
Sounds like too, I think what I heard you say was one of the remedies that you were interested in here, that you didn't receive, right, that wasn't implemented, was your removal from that particular class.
Correct.
So that, again, in follow up to Commissioner Douglas's question, although they, school did implement a series of measures to try to correct for the behavior, there was a remedy still on the table that wasn't implemented that you feel like would have been effective under the circumstances. Okay.
Yeah.
Can you tell me more about how do you know that this cohort of students did not receive training and education on the topic?
I know it was never mentioned.
It's
I just said if it's in the record.
if it's in the record, do we know? I'll ask.
No, there was, when I looked at the thing, what they had done and what was in the campus, there was a lot of stuff missing. And I provided emails
I'll ask
for some of that stuff.
Sure. I do just want to everybody know we have 9 cases on the hearing agenda today.
We know. We know.
Okay.
Just very briefly.
Ed has to leave at 3.
We'll leave.
We're gonna be done by 3.
Exactly, that's, okay, yeah, go ahead.
Just briefly, the report says that I think you said there was no further harassment after the students were removed from your class. Is that accurate?
Yes and no.
Okay, well, tell me how no. How is it not accurate?
Other students were still pretty disrespectful toward me. I mean, I wouldn't say it was harassment, but I think they witnessed this go on for so long that other students who weren't a problem started. And actually, one student wasn't removed, who was literally towering over me, misgendering me, with the principal standing right there. The principal escorted him out, but I mean, I for a second thought that kid was gonna punch me.
But were they misgendering you? Or
He
were
did,
they-
yes, he
Okay.
did, yeah.
After the other kids were.
After the other kids were removed, correct.
Thank you.
Real quick.
Yeah, you said a moment ago that the school system has all kinds of policies. I almost, how do you react to this challenge? Are you asking the Human Rights Commission to second guess those policies and to imply that they need to be rewritten in some way, or?
No, I'm asking for them to be enforced when they're violated.
And your allegation is that the policies as they are written were not enforced? Correct. Okay, and there's an investigation that, what, you say whitewashes that? The internal investigation? I don't mean our
that one?
investigator, I mean the internal investigation that they hired an impartial investigator.
Oh, are you talking about, well, I don't know, impartial, Drummond Woodsum is on retainer with Portland Public Schools. I mean, how independent can you be?
Okay.
That's, I don't, there's a question I have.
That's a valid point. Thank you.
Very briefly, the restorative justice process, I know can work and sometimes, as you're saying, it's dysfunctional. But in that process, were you able yourself to use the word harassment and talk to them about why that, what that means to you? And I guess that's.
I'm not, honest to God, I'm not sure. I may have used the word harassment. I was also feeling like pressure from somebody who knew the students, who was running the restorative process, like, and he just kept saying, this is inappropriate behavior, which is true, it is. I had no qualm with that. And disrespectful, again, no qualm with that. But at the end of the day, I really just I guess I never felt safe. I didn't trust people. And I don't think the principal should have been doing the restorative justice process. Like somebody else should have come in that wasn't involved with me. But anyway, they did the best they could, I'm sure.
You'll have about 1 minute and 10 seconds when we come back to you.
Okay, thank you so much.
I am expecting Attorney Huey for the respondent or somebody for the respondent.
Yes, good morning. This is Gina McCormick from Drummond Woodsum. I am covering for Attorney Huey this morning, who unexpectedly was unavailable.
Great, thanks, Gina McCormick. All right, you have 10 minutes, Attorney McCormick, whenever you're ready, go ahead.
Thank you very much. Good morning, Executive Director, and good morning, Commissioners. I appreciate your time this morning. I would like to first just point out the standard for overturning the investigator's decision, which is an error of fact or an error of law. And we've not heard that either in the written submission or in the oral remarks this morning. I would like to point the Commissioner's attention to page 4 of the investigator's report, It lays out the legal standard that's applicable in this case. As we heard Mr. Kulas say this morning, and I wrote it down, perhaps Portland Public Schools met the legal standard. And in fact, they did. The legal issue here is whether Portland Public Schools took immediate and appropriate corrective action after learning of the student conduct. And the record in this case is replete with evidence showing that the school did in fact take prompt and appropriate corrective action. It's in various places in the record. It is in the school's response at pages 3, 4, and 5. It is evidenced in the report that is attached that was conducted, that the school hired an investigator to perform. In that report, it shows that on October 13th, when Mr. Kula radioed administrators, 2 administrators immediately reported and provided support to resolve the issue. Similarly, on October 17th, when there was an issue, an administrator responded for Mr. Kula's request for help and removed the offending students from class. Similarly, on November 3rd, the students were sent to the office. If you look at Portland Public Schools' final submission dated March 28th, 2024 on page 2, there's a chart that very clearly lays out the dates of the 3 incidents that were reported to administration, what happened, and what the consequences were. In addition to the disciplinary action that was taken, as Mr. Kula discussed, there was restorative justice processes that were followed. I understand from Mr. Kula that he may not be satisfied with that entire process, but I also heard him say that the administrators were doing the best that they could here. There is no doubt, based on this record, that the administrators took these concerns seriously and acted to address the inappropriate conduct with the students, as well as to try and help these students continue to be able to be engaged in the educational process. As the investigator pointed out, there is no fixed requirement under the law for what constitutes a correct response. We're talking about students. They are 14-year-old students. They did engage in harassing conduct. As one of the commissioners said, that is not disputed here. But the school, as soon as it found out, took those concerns seriously and acted on them. And that is why the investigator's finding of no reasonable grounds must be affirmed, because there is not a basis under the law to find employer liability here. There were a couple of questions that were asked by the commissioners that I would just like to address ahead of time, and then I can answer other questions. There was a question about whether the complaint filed by other students. There's a copy of the investigation report from that situation as well, where some students raised concerns about Mr. Kula's conduct in the classroom. At that time, Portland Public Schools hired an attorney from the law firm of Murray, Plum and Murray to investigate that situation. You have a copy of that report. It's Exhibit D in the school department submissions. And another question that I think was asked was about Mr. Kula's tenure with the school department. As he stated, he had been at the school for 4 years. This incident happened in the fall, I believe, of his 4th year, and spanned a 6 to 8 week period. And again, during that 6 to 8 week period, the administration was working on it every single time it came to their attention. And at the end of that 6 to 8 week period, in addition to the disciplinary action that was imposed on the students and the restorative justice, the students were removed from his class and he was assigned to teach at a different time of day so that he didn't have to interact with those students. And the investigator found that the harassment ended after that. So yes, it did take the school department 6 to 8 weeks, but under the circumstances, that was a reasonable amount of time. I'm happy to answer any questions that the commissioners may have.
Thank you. Good morning, Attorney McCormick. Just a quick question for you about one of the remedies Mr. Kula allegedly asked the administration to implement, that again allegedly was not implemented. He asked to be removed from the class. It sounds like prior to the time the students themselves were removed, and I'm curious if you could shed some light on that question, the answer to that question, as well as the rationale for in fact not implementing that remedy Mr. Kula requested.
So Commissioner, I'm happy to talk with you about what's in the record that's responsive to your question. The evidence that was included in the record shows that after Mr. Kula raised concerns about these 3 particular incidents involving students, that the administrators were regularly attending class and trying to assist with the classroom management. I do not have record evidence responsive to Mr. Kula's specific comment. I believe he said something to the effect that he had asked to be removed from the class sooner, and an administrator said he should continue to teach. What I do know that's in the record is that soon after the November 3rd incident, some of the students were removed from his class. When he expressed discomfort at teaching in the gym at the same time as those students were in the other gym class with the other teacher, he was then assigned to teach at a different time of day, the first period of the day. So that's what's in the record and what happened, ultimately assigned to a different class within that 6 to 8 week period.
Thank you, that's all.
There are commissioner questions for Attorney McCormick. Commissioner Douglas.
Good morning.
Good morning.
The legal standard that you directed us to on page 4 of the report contains the word immediate. And I'm just wondering, the 6 to 8 week time period that Mr. Kula takes issue with, I heard you say that when issues came up, the administrators responded promptly, but Mr. Kula feels that, he waited roughly 8 weeks for a resolution, as he terms it, quote unquote. And I just want you to address how that meets the standard of immediate beyond what you've already said about the administrators. I fully credit that point that you've already made.
Sure. Well, as we sit here today, right, we can look back and see that this behavior continued over a 6 to 8 week period, but we have to put ourselves in the shoes of the administrators at the time this was happening. It was the beginning of the school year. It was a new freshman class. It was a particularly difficult freshman class, and they didn't know that this behavior was going to continue. Again, 3 specific incidents. Every time there was an incident, the administrators were in the classroom disciplining the students and following through with restorative justice. Commissioner Douglas, after the 3rd incident, when it became clear to the administrators that this was something that, yes, happened once, twice, a 3rd time, okay, now we've got to do more than just discipline the students as it happens. This cannot continue to happen. So they were removed from the class at that time. It's something that unfolded, and that time period was actually shorter. The first incident was October 13th. The 3rd one was November 3rd. And on November 3rd is when the students were removed from the class. And as the investigator noted in her report, these are 14-year-old students. The school has an obligation to try and discipline and educate these students as well. Expulsion is not an option right away. There is a legal standard that somebody has to meet to expel a student, and that was not an option on the table. These are kids who need to be educated, as well as the teacher who needs to be protected. Absolutely, Mr. Kula should not be subject to students engaging in that kind of conduct. That is inappropriate and should not happen. And the school did everything it could to shut it down, and did shut it down. It ceased.
Okay, thank you.
Other commissioner questions for Attorney McCormick? Seeing none, thank you, Attorney McCormick. You'll have about 4.5 minutes left when we come back to you.
Thank you.
Mr. Kula, you have about 1 minute and 10 seconds. If there's anything else you'd like to add, you're not required to, but if you'd like to, please feel free.
I never asked for an expulsion, never on the table. And I want to just clear something up about switching a different class. I went to the administrator because they switched to teachers, but we were both in the gym at the same time. And she was there for another 2 weeks before she was removed again, not immediate, not once. Prompt, immediate response, never. I was on a radio begging for somebody to help me. And then co-principal once said, well, Jake, what do you expect? Students are gonna laugh at you. I disagree with, and also, only 3 were reported. Oh no, I was in their office far more time in discussions. They just chose not to document it. Thank you.
Any other commissioner questions for Mr. Kugler?
Oh, sorry. I'm not used to these procedures.
I don't see any, so you're welcome to sit down. Thank you.
Okay, thank you.
Attorney McCormick, you have about 4.5 minutes left. If there's anything else you'd like to add.
No, thank you very much.
Seeing none, thank you both. We will next hear from Jan O'Reilly, the investigator assigned to this case.
Oh, this is gonna slide off of here.
Good morning, Commissioners. My name is Jane O'Reilly. I was the investigator on this case. I don't have a ton to add. I do have a lot of notes, but I think I'll just say that I think it's been correctly identified what my reasoning was in this report, that, harassment, undisputed. Mr. Kula was subjected to harassment on the basis of his gender identity by several students in his class. It escalated. The school responded as it was happening, escalated their response as well, and I found that they met their legal obligation for prompt and appropriate action. The harassment ceased, and therefore there's no legal liability, but I can answer any questions.
Commissioner questions for me?
Commissioner Sanders.
I thought it'd be better to do this.
You know last week.
It's almost a rhetorical question, given the content of the report, but I just want you to confirm that you feel that the response of the school was adequate to not really a legal standard, but I'm just curious, to keep Mr. Kula safe.
Yeah,
And have him in his classroom in a safe and appropriate manner.
So I'll explain that more. So first of all, it's very difficult, right? The feeling of safety, the feeling like once it's happened, it's never gonna happen again. There's really nothing the school can do to ensure that nothing will ever happen again in terms of harassment. Second, it was clear from both Mr. Kula and the administrators when I interviewed them that though there was this class of gender identity-based harassment, there was a lot of misbehavior in this class. And it wasn't completely clear whether or not the students were using these tools, these gender identity-based statements. It doesn't matter in terms of the response needed, but whether or not, well, that it violates law, but whether or not they were using these tools specifically because they had a bias or because they were trying to be mean, right? Or they were trying to target Mr. Kula in a way that would be the most offensive. So the school was dealing with both of that when they were trying to talk to the students about the inappropriateness of the behavior. Third, my footnote that's been talked about a lot, sort of the age of the students and what qualifies as prompt and appropriate response. It's not really about the maturity, I guess that word was used by Mr. Kula, if they're mature enough to understand, to use the comments, they're mature enough to understand the consequences. It was more about, what kind of intolerance you give versus, how many times you try to help before you escalate the behavior, right? So the attorney for Portland Public Schools, Attorney McCormick today referenced a document you guys don't have in front of you because you don't have the record. The chart that talks about the responses to incidents, that's in the report. That's that outlined. They had this incident. But I think it starts with some in-school suspensions. It starts with out-of-school suspensions. It's also not clear. I was trying to look it up, but it's not the same student. I mean, I would have indicated in these things, it's not the same student each time. It is the same group of students, which is why the incident was, the responses were escalated. But in my interviews with everybody and my review of the documents provided by the school and how they responded, I believed, and I still believe, that their response was prompt and appropriate, right? They pulled the students aside. I mean, in one incident, they pulled the students out of class. In the moment, Mr. Gulab called for help. The athletic director showed up immediately and that student was immediately removed from class once the principal arrived and taken to the academic office. So they weren't allowing these situations to, to continue in front of them. And when they learned about them, they were escalating them.
So just to summarize.
Can I?
It's gonna be very discreet.
Yeah.
The individual instances that Mr. Kula reported, the school would respond immediately.
Yes,
In your view, without exception.
yes,
And then the investigation or what have you took a little longer to sort of wind through, but they were responding in real time in the meantime.
absolutely, yes.
Thank you.
That was one of my questions. We'll be really efficient here. Just curious about, is it in the record whether or not or how students in fact were trained?
So it was a long time ago when I interviewed the principal. So I interviewed co-principal 2, who was the one who held the meetings. And I was looking for it in the IRC notes while I was talking, but also trying to listen at the same time. So let me actually just take a minute and try and find it, since I know you know the answer to that question. Okay. So I did get him on the record saying he talked to them about discrimination, that we don't want this happening in the school. He said he recalled that he recorded things in the internal system. I do have those. I think I have those submissions as well, that he, wrote something, he emailed the parents, I think. Let me not say that. Yeah. Okay, all right. The documentation of the school system is just whether or not what the discipline was that they received. But he couldn't recall exactly what he said about them, but he talked to them about discipline. He also talked to them about the students themselves. Again, this is where the sort of the confluence of the two issues come up when he talked to these students. These were students who were struggling in other areas. So we didn't just talk to them about, the comments they made were unacceptable, and here are some other ways that you're sort of misbehaving in class. And again, that was common in the investigation, that those two issues were, I know Mr. Kula had an issue with that, but that's addressed in my footnote. Sorry, it's a very big record, so I'm trying to very quickly find these.
Any other questions for Investigator O'Reilly? And thank you, Jane. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. One proposed finding.
I move to accept the investigator's recommendation as written on page 4.
All right, it's been moved and seconded. Any discussion?
I just want to say, Kula, that I appreciate where you're coming from, and I appreciate what happened to you on this record. I understand why you're here today, and I want to commend you for raising your voice on this issue. These sometimes you raise your voice and successful, and I think you're not gonna be successful today, but I also think that sometimes you are heard and changes can be made regardless. On this record, I just don't think that it looks like the school didn't respond appropriately and immediately within the applicable law. So.
Yeah, I want to second that, Mr. Kula. You make an excellent presentation. The harassment is totally unacceptable. The difference is that the respondent is not an employer with the authority of disciplining co-workers of yours that are harassing you. They're in that unique responsibility of an educator. They have power, they have policies, and I just have the feeling that for us to say that response is qualitatively insufficient is us second guessing their policies. If the policies need to be changed, that's through their committee process and the public school board and all of that stuff. It's a close call, but I will be supporting the motion.
I would echo that. I think you did a very good job advocating for the harassment that you experienced. The key issue that we have to answer is 6 to 8 weeks a prompt and appropriate response. There were steps they took. They did certain things they may have been able to do better. Maybe what you outlined would have been a best case, best policy practice, but I think they probably fell within the legal guidelines.
I feel the same. Your advocacy is impressive, and I want to thank you for that. You're part of the solution as we think about ensuring that an educational setting is safe for everybody. So I want to thank you for that. You noted that even if I think you noted in your initial presentation that given the legal standard, you reflected that perhaps the legal standard should change. That's certainly something, given your advocacy skills. My hope is that, in the communities that you're a part of, that you continue to advocate for the issues that we've raised here today. My hope too, right, on this record is that the Portland Public Schools use this as a learning opportunity as well, and to the extent that there are gaps, Attorney McCormick noted, right, hindsight can be really instructive. If there are gaps and opportunities to improve, the schools use this as an opportunity to do just that. So thank you.
Other discussion? All right. Seeing none, the motion is to find no reasonable grounds. If you're in agreement, we'll vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
The findings are no reasonable ground. We appreciate everyone's participation, and the commission will send a letter to the parties and to the council confirming the results of the hearing.
Could we move the screen just a foot to the left?
Yeah.
Sure. There you go.
Stand up and change.
We all
Yes.
second that motion.
Great.
Another 4 inches, yeah, that's
There
great, thank you. The next case that I have is.
Can I just say one thing quickly?
Well, we're done with the discussion.
What is it?
Oh, yeah, absolutely. We're always, you don't hear that.
Thank you. I kind of figured it was gonna go this way. That was my expectation. And thank you for acknowledging that, yeah, in the end, I do this as part of my healing process and to advocate so that in the future, Portland Public Schools could do better, and I hope they're already doing better. I wish no ill will on anyone. Thank you.
Thank you very much.
Thank you.
Mr. Kula. I
Thank you.
appreciate that.
Next case is E23-0119, Virginia Brown versus Bank of America. The recommendation by the investigator is for a finding of no reasonable grounds on both counts. And we'll hear from the complainant.
Chair, I have to recuse myself from this case.
Oh, okay, thank you.
I believe Ms. Brown, yes, you're on Zoom. Okay, great. So you have 10 minutes. Whenever you're ready, go ahead. You are muted right now.
Thank you. Thanks. Good morning. Thank you very much for your time. I'm very grateful to have this opportunity to speak with you. Certainly, it was a long process getting here, and as I said, I'm very grateful for your time. I did read the instructions and am aware I should only be speaking about relevant factual errors, relevant facts submitted but possibly left out, and relevant issues or questions concerning the interpretation of the law. So I'll be sticking to those things. Basically, and I do believe you have a copy of the investigator's report in front of you, and I appreciate so much the work that was done on that investigation. I know there was a lot of information, and I know that a majority of my experience and concerns were deemed to have taken place outside of the time frame that you can consider. So I appreciate the investigators' work sifting through that information as well. So I'm just really going to go through some of the points I wanted to clarify regarding the summary of the case. In 2019, I was employed as a financial advisor, not a wealth management specialist, and there's a significant difference there. In 2019, my divorce proceedings began. And that's important too. High conflict divorce proceedings took place over 3 contentious years. So they took place during the 3 years that I was concerned with. The divorce was not finalized until the fall of 2022, just prior to my termination from Bank of America. My former spouse was a market executive overseeing the referral flow and many other influential factors in my immediate work situation. He wasn't just simply another one of the 20,000 employees of Bank of America. The state of Maine, not myself, but the state of Maine filed felony assault charges against him. He was a senior executive vice president, Bank of America, working in the same building as myself among less than 40 people. So some of the respondents' submissions try to make it sound like we were just, two fish in a giant ocean of employees, but that's not the case. The protection from abuse order was a separate document from the criminal charges and the indictment. The protection from abuse order was effective immediately for 2 years and with a 1-year extension for a total of 3 years, which is the maximum. It's the maximum charge, and I just want to point that out. I was never offered any accommodation. I sought an alternative job post on my own. The wealth management banking specialist position, the location when I posted for that job was TBD, to be determined. But it is true that I did accept the position and I moved forward with it, knowing after learning that they decided it would be located in New Hampshire. And so I did it. I knew it would be in New Hampshire after I was offered the position. But I really felt at that point that I had no other choice, because over a time period that's not going to be considered for this hearing, I had worked with HR or tried to work with HR, to get some relief. And this was taking the job in Portsmouth, New Hampshire was really, I felt I had no other choice. After some time, the commute did become a hardship for me, which I did communicate with my manager. my medical condition did require extended leave. I wasn't granted extended leave by Bank of America. And as I approached the 6-month mark, I'm the one who reached back out to Bank of America at that point. No one had contacted me. I wasn't even sure who my manager was at that point. So I'm the one who actually initiated the contact that resulted in my termination. Joellen Garcia replied to my request to touch base. And
Use the name of third parties, Ms. Brown.
oh, I'm so sorry. I'm sorry. Well, she, okay. Anyway, so when she responded to me, I was shocked because that she said I was required to report to the office in Portsmouth the following Monday. I was still suffering from severe depression. I had many medications, shingles. I was still attending therapy twice a week. Many of those things are still true. And so returning to the office in Portsmouth, New Hampshire, that following Monday, I did not feel was possible. In the meantime, I've been receiving correspondence from Unum, who stated I had been referred to them by Bank of America as a long-term disability case. And because I had signed authorization, which I did include in the documents I provided to the investigator, to share my records between medical providers as well as insurance companies for those purposes. My medical records were available in between the numerous insurance companies communicating with Bank of America. I was approved through November. And then shortly thereafter is when I began receiving requests from Bank of America that they wanted explanations directly from me regarding my return to work status. But previously to that, any official word on my medical status had to come through, not from my mouth or my communication. That wasn't good enough, which I understand. It had to come from my doctor's office through, the insurance company in order for it to be valid. Yet at this point, Bank of America was requesting it from myself, for me to state how I was doing or when I was coming back to work. So it was a complete change in process, which I thought was odd. And I kept preferring them to leave me alone and to get the information from the insurance companies. And I do admit I was very unpleasant to talk to. I admit to reacting terribly. I was not well, clearly, and I felt that I had been harmed by Bank of America. And now I was being unnecessarily harassed by them for information that was already available to them. And normally they wouldn't have accepted that information from me anyway. I don't know why the investigator states that the report includes the insurance company was not used by Bank of America. Unum, Provident, that is the insurance company that Bank of America does use. It's Unum, MetLife, Provident, Sedgwick.
Brown,
They
please
all
don't
work.
use Ms. Brown, please don't
Yes.
use the name of entities that are not parties to the case.
Okay, I apologize. Insurance companies are interchangeable depending on the year. One company provides short-term disability, another company provides long-term disability, and I believe I did provide that documentation as part of it. my packet to the investigator as well. I cooperated with the insurance companies and my doctors and,
That is your 10 minutes.
okay, thank you.
Any commissioner questions for Ms. Brown? Commissioner Douglas.
Yes, Ms. Brown, good morning.
Good morning.
Yeah, listen, I just wanted to give you the opportunity to explain to us why you think you've been discriminated against based on your sex, the fact that you're a female. That's what your complaint says. And in order for us to find for you, we have to find some reason why you were discriminated based on your sex. I mean, I understand there was a dispute about your leave. They say they didn't hear from you. You maybe say something different. But let's assume even if they did hear from you, why was your termination
Right.
improper because of your, just focus on that, that'd be great.
Thank you. And I appreciate that. And I think that the reason why that first claim of mine is being dismissed or declined is because when I initially filed my complaint, I had included a description of harassment that I had experienced, which subsequently was decided not to be considered because of the time frame.
Okay. All right, thank you.
Thank you.
Other commissioner questions for Ms. Brown? Seeing none, thank you, Ms. Brown. We will next hear from Attorney Massey.
Good morning. This is Tiffany Manos. I submitted a notice of appearance a few weeks ago. Ms. Massey is also an attorney for Bank of America in this matter, but I will be presenting.
Thank you very much.
Good morning, Executive Director. Good morning, Commissioners. Taking your time and being here and hearing this matter. Just at a high level, what I'd like to do is address a couple of things that Ms. Brown mentioned and explain why they do not impact the legal analysis in this matter. So as you know, it is her burden to point out an error of fact or a fact that is relevant that was left out of lead investigator O'Reilly's report, or some error of law in the investigator's interpretation of the law. She has not shown any of those items either through her presentation or in the written submission that she made. I heard Ms. Brown mention her job title. So just to kind of give some context here, she filed her complaint in March of 2023. And so she can go back 300 days in challenging an alleged adverse employment action or discriminatory or retaliatory act that takes her back to June of 2022. So that is why we are looking at that time period of kind of mid 2022 through her termination on December 1st of 2022. Certainly, some background is helpful to have, but the job title, I mean, at the time that we're looking at, Ms. Brown, as she said, had applied to a different position, which was wealth management specialist. And she had transferred into that. She accepted the offer from the bank. They offered her the job. And she then also moved to Portsmouth, New Hampshire. So she was not in Portland where her ex-husband was located. So there was no issue there of her ex-husband impacting her job duties. She never reported to him. They're in different reporting structures on different teams. I also heard Ms. Brown mention when her divorce proceedings began. I mean, frankly, that we don't see any relevance to the matter. I mean, it's a personal issue. And I think we mentioned this in our position statement in our written submission. When the bank tried to assist Ms. Brown in returning to work, to try to understand, why are you still on leave? Do you need any assistance? Is there any work-related concern you may have? What she said was, the issues in my personal life are creating a hostile work environment. And so there was, there's nothing that employer can do if somebody's personal issues or creating a hostile environment. They try to look into whether there was any work concern, but there was not. So I think that's where the divorce comes in, that as she mentioned, it was still going on in 2022 at the time or around the time of her termination. With respect to the leave and sort of this dispute of fact, I don't think on the record there is any dispute of fact. We submitted copies of a few communications to Ms. Brown. What happened was she began a leave in April of 2022. The bank's third-party provider, I can give the name if you'd like, but I understand I should not mention the name, begins with an S. The third-party provider for employee leaves granted her a couple months of leave and then 2 extensions, which took us to mid-August. Her medical provider didn't submit any additional documentation, so the leave expired on August 14th of 2022. She then didn't submit anything else from her provider. The third-party provider followed up, received no information from her. The bank then, as it should, reached out. This was in the fall, and said, you're on an unauthorized leave. We need you to please submit additional documentation or return to work. They sent several communications. She did respond in November, and instead of saying, yes, I need more time, here's the information, or here's my provider, please ask them, she reacted with hostility, saying, stop bothering me. And the bank gave her several warnings. If you don't return to work or submit additional documentation of your need for additional leave, we will need to terminate your employment. So this went on for another month, and then after a final communication, her employment was terminated effective December 1st. This had nothing to do with Ms. Brown's sex, with with a protection from abuse order that she got there, with any purported protected activity. The investigator correctly found there was none. She did not raise any concern of discrimination or harassment. It was simply due to the fact that she failed to provide any additional information to show she needed to be on a leave or to return from work. So I believe that addresses what she raised. She mentioned a different provider. The bank does use a different third party to handle disability, short-term or long-term disability. It's not relevant. I mean, the bank was reaching out directly to her to say, we need this information. How can we help get it to us? We just need something from your doctor, anything to say you need more leave. And she did not respond. Well, she did respond, but not to the question and to the inquiry. So turning back to the investigative report, I think investigator issued a well-reasoned report. And the facts that Ms. Brown pointed out that are incorrect, I'm not sure that they are incorrect if you look at the time period we're talking about. But even if you're going to say her job title was not technically correct because she had a previous job title, it does not impact the legal analysis. So I will conclude with, we ask that the commission accept the recommendation of the investigator and find no reasonable grounds to believe that discrimination or retaliation has occurred.
Attorney Manos, you will have about 2.5 minutes left when we come back to you. Any commissioner questions for Attorney Manos?
Good morning. I'm troubled by the fact that if the domestic abuse that she suffered is the cause of the disabling conditions later on, why is it time barred to be making a claim based on that continuous situation? Why should it be barred? You're saying that the domestic abuse that she suffered should have been the basis of a complaint earlier within the 300 days.
Well, we don't know what she's claiming the medical condition relates to. I don't believe that is part of the record. I don't believe there was a medical note. But the reason that I think with the time frame, the reason we're looking at 2022 is because we're looking for she has to show, some adverse employment action taken by the bank. And so that's the time period we're looking at. So, I mean, the adverse employment action, as the investigator correctly found, the only one at issue here is her termination. And so then we're looking at, okay, was her termination due to discrimination or retaliation? So those are the legal issues. She tried to bring in the transfer and to say it was involuntary, but that one is time barred. The reason for the termination certainly is at issue here, but the reason she was terminated had nothing to do with.
I understand that, but you're saying that the adverse action could not be the failure of the bank to adequately address the abusive individual in that closer work environment, correct?
Well, there's no evidence that there was any abuse in the work environment.
Well, sure there is. There's the severity of the protection order and the felony charges against him.
Yes, but respectfully, that happened outside the workplace.
Okay, thank you.
Any other commissioner questions for Attorney Matos? Seeing none, I said you would have 2.5 minutes to come back to you, but complainant has used all her time, so we will not be coming back to you. At this time, we've heard from the parties, and we would now hear from Investigator O'Reilly.
Good morning, commissioners, again. Again, I'm Gina Riley, I was the investigator. And I'll just go straight to your question, Ed, about the timeliness in this case. So the issue is for sort of the ongoing issue of the domestic violence. So receipt of a permanent protection order was one of the bases that complainant alleged was discriminatory. In order for there to be sort of an ongoing, harassment issue related to that, there has to be an adverse employment action within the job. So as early as February of 2022, she had applied and moved out of and was no longer in the same work environment in Portland when she complained that when she reported that she needed to be out of work, that she needed extended leave. They asked her is there an ongoing work issue that is causing problems? She said, no, it's issues in my personal life. So at that point, even though the effects of the abuse were ongoing, there was no adverse employment action in the work environment related to the abuse that was ongoing.
But the argument is that the adverse action is the failure to act, to remove that abuser from the workplace.
Right. So once the failure to act has occurred, unless the failure to act resulted in ongoing harassment within the workplace.
Okay, all right.
See what I mean? So the failure may have happened and it may have been a hostile work environment. They may have totally failed to act. This report doesn't address or analyze any of that. It may all have occurred, it may all have been terrible. I have no idea. But I focused the report on whether or not anything occurred within that 300 days. And she had already, the work environment was free of the ongoing issues. And then again, when the report says on the last page, it may be unlawful to deny leave or deny approval for leave if the reason given for the leave is the reason for the denial, right? If she had said, I need to continue leave because I'm still suffering, I have disability or I'm still suffering the effects of this abuse. And they had said, no, we don't approve. That may have been discriminatory, but she didn't provide any reason.
Right.
She just stopped.
Good, thank you.
Any other questions?
And to be clear, right, this case was filed as a case alleging discrimination on the basis of sex, not discrimination on the basis of disability.
Correct. Yeah, it was receipt of a permanent order of protection and retaliation for the reports of hostile environment previously. Any other questions?
Thank you, Jane. From the parties and the investigator, at this time we'd be looking for a motion. There are 2 proposed findings.
I will move to take them together and to find that there's no reasonable grounds to believe that respondent discriminated on the basis of sex, and no reasonable grounds to believe that respondent retaliated in violation of the acts of whistleblower and main human rights.
Second.
I assume council has reviewed the statutory.
Barbara is here for your legal questions. Colin's here to keep you company right now and to get a first-hand perspective on how this works. So the next time Barbara's out, he can answer those questions.
Is Barbara here?
She is here. Yes. Barbara, can you join us?
Did you hear my question, Barbara?
I did not. I apologize.
I'm saying, I assume you reviewed the statute of limitations question, which is what had been bothering me.
Yeah, absolutely.
Good enough.
Thanks. All right, any other discussion? Seeing none, the motion is to find no reasonable grounds on both findings. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Yes. Okay, so the findings are no reasonable grounds. We appreciate everyone's participation.
Yes.
And the commission will send a letter to the parties and the council confirming the results of the hearing. Thank you. Take a 5-minute break.
Yes, we'll be in recess for 5 minutes.
No, go ahead.
order. The next case is E 22-0193 Clifford McNeil versus TD Bank. And that's a no reasonable grounds recommendation by the investigator. We'll hear from complainant.
Morning. Morning, Attorney Lee, you have 10 minutes. Do you want to reserve any of your time?
Yes, I don't believe I'll use anywhere close to the 10 minutes. I'll move you along more quickly, hopefully presenting this a little more efficiently for you. I think do most of the work via your questions, because I think that's what's actually most important. During the 4+ years that Cliff McNeil worked at TD Bank, he received high ratings and demonstrated high sales statistics relative to his colleagues in the call center, yet was never elevated above his original higher position at the call center. His younger colleagues, by contrast, were repeatedly provided opportunities for career advancement, particularly through internal career advancement program. Cliff never called out sick. He was never late. He was never disciplined. And unlike many of his colleagues who were advanced, he had prior managerial and leadership experience. Cliff came to the call center with an accounting degree. He had successfully managed his own business. He had been the chair for the select board of the town of Sumner and thereby managed a budget of $1.7 million. He was an exemplary employee, as demonstrated by many of the reviews that he received, and demonstrated that experience that he had, which predated his work at TD, but was also a significant part of his work at TD, mentoring those younger colleagues who came into the call center, ultimately who were advanced above him, though coming in later than he was. He was qualified for many of the positions that his young comparators were repeatedly provided training and opportunity to obtain. The biggest, I think, question in this case, and I try to isolate it to the investigator's report, the actual place where I find there to be a factual or legal issue. And I think it starts as early as footnote 1. Where the investigator decides that the complainant alleged that he was not given equal access to training and career advancement opportunities. However, a complainant failed to provide evidence in support of this. I think there's ample evidence in the record to demonstrate that he was not provided those similar opportunities. In fact, this is one of those cases where things have become clear over the process of the investigation. And what has been most clear over the processing of the investigation is that the key to unlock the door to career advancement at TD was the internal career advancement program itself. Contrary to the assertions made by TD, as well as the assertions made in the investigator's report, as experienced by Cliff, who was much older than the folks who did receive opportunities to participate in that career advancement program, it wasn't a program for which one applies. It was one that basically managers would select individuals for the career advancement program. Mr. McNeil was not selected despite demonstrating his excellent work ethic, proficiency, and leadership, despite all of the experiences that he had, and frankly, despite ample record evidence that shows that he was addressing his opportunities for advancement with anyone who would talk to him about it at the company, including a fairly high-level individual who got him some help with his resume, but did not present to him, hey, we have this internal career advancement program that is really the Rosetta Stone to advancement at the company. It can't be overstressed how vital participation in the career development program is at TD. It's a vital tool for advancement at TD. Mr. McNeil demonstrated his desire to advance at TD, was never presented that as a possibility that he could self-apply for, evidently, and advance his way through. As noted, frankly, in another footnote, the footnotes is actually the most important part of the investigator's report here. In footnote 3, it's indicated that there were several individuals who were able to complete the career advancement program who were typically advanced 2 or more levels in leadership roles at the company, despite the absence of performance prior and despite the existence of any existing leadership or managerial skills. It was really advancing through the career advancement program allowed you access to a job 2 levels higher from the job that you had. Evidently, the issue that Mr. McNeil had in the applications that he was submitting, despite, again, ample record evidence indicating that the folks who were above him at TD were cheering for him to get those jobs, he's now told that the reason he didn't get those jobs was he had not, that he was applying for jobs that would require him 2 levels of advancement. Well, the way to get 2 levels of advancement appears to be access to the training program, which he never had the opportunity for. And none of the individuals who said they were cheering for him to get a job advancement ever presented him the opportunity to participate in that leadership and training program. And so that to me is the nub of the case, right? There's a lot of discussion that happens as to the individual jobs, but it's evident and it's quite apparent from the investigator's report, as well as the assertions made by TD, that the absence of his access to that training program was the reason that he was not able to advance at TD. We would argue, and you know, we've submitted to the investigator responsive to some questions about 6 different comparators, at least in the Auburn office, of people who were able to advance, who are significantly younger than Mr. McNeil. It's now evident, and frankly, this is one of those places where the absence of discovery in the Human Rights Commission process is somewhat detrimental to my ability to prove the case. But we would believe that the evidence would demonstrate that the folks who were offered the opportunity for the career advancement program were substantially younger than Mr. McNeil. And so I'd be happy to answer your questions and reserve whatever time I have to rebut.
Questions, yes, Commissioner Duckworth.
Yes, Attorney Lee, good morning.
Good morning.
Yeah, so I understand this is an age discrimination claim, and I'm just looking at the report, and I mean, there are a number of jobs here, right? And there's a lot of data. But it looks like just in terms of evaluating your age discrimination claim that, you know, the company hired people, a wide range of ages here, right? I mean, I'm looking at, for example, page 3 of the report, paragraph D2, for example, we're talking about a remote loan processor 1, and the ages are 26 to 67. Paragraph 3, you know, the person hired was 48, your client is 53. Paragraph 5, 48 years old. And on and so on. So I guess what I'm wondering is just sort of thinking it through from like a trial lawyer perspective, right? How are you going to prove, what's your best evidence on the age discrimination? Like, how are you gonna demonstrate that? Is it that he didn't get access to the program, the LIFT program, because he's older? Is that the claim? Is there a claim? Does it go beyond that, I guess?
I think that's precisely it. And there is some nuance here, right? As to who you're deciding are the comparators. So those individuals who are more aged, who received employment, were folks who came from outside of TD. And relative to the individuals who were promoted within TD, all of those individuals were substantially younger from our perspective than Mr. McNeil. And the way that they got access to that internal promotion was via this training program that he didn't have access to.
Okay, and so just to follow up then, so I'm looking at respondents' response to the report, page 2, and you know what they say is that this LIFT program is a self-nomination leadership program to individuals who express an interest in advancement by volunteering, underscored, for the program. And then they say throughout his employment, your client was eligible to voluntarily enroll in this program but he never enrolled or expressed interest. And I'm gathering from your presentation, you disagree with that.
I substantially disagree with that, and the quotations that are in that portion, I'm not sure where those quotations were coming from as to what how the program exists, but as it was experienced by my client, that was not how it existed. And frankly, if they have a program like that, my client talked to several of the people who are in managerial positions, and you have those conversations, some of them in the record in our reply exhibits, that are conversations he had with fairly high up folks at TD saying, hey, I'm getting nowhere here. What can I do here, right? What can I do to change the responses that I'm getting to my applications? It seems as if the primary way to advance at the company is to take this leadership program that one can self-nominate for, that would have come up in those conversations. It didn't. And so the question as to whether this is how does one self-nominate? It doesn't appear that there's a procedure that my client was ever aware of. I've seen no indications in the record or otherwise that there is sort of this equal access to application to this program. He certainly would have applied for it if he knew it existed as something he could apply for.
Right. I'm picking up what you're putting down. Thank you.
Commissioner Sanders. Sure. Good morning, Attorney Lee. Thank you for your presentation. Just a couple of questions in follow-up to Commissioner Douglas. I think I just want to confirm my understanding. I think what you're saying is that if we look at the data differently than what's presented here in the report, so very concretely, if we look at the data of internal promotions versus external hires, you allege that we would see data that suggests, right, or could support that there's something amiss with TD Bank North's internal promotion practices. Did I get that right?
Yes, I believe that's correct. And so the proper comparators are not necessarily all hires for all positions. The proper comparators are those who are hired internally who had access to this training program.
Okay, great, that's helpful. And can I also ask too, I think you noted the Auburn location in particular. Are you also alleging that with respect to that particular location, if we look at the data that reflects both internal promotions and maybe even external hires, that we may, or we would also see some data or evidence that may support your claim? Do I understand that correctly as well?
I'm trying to, so as specific to the Auburn location? Yeah, so again, Mr. McNeil only worked in the Auburn location, and so that's the information anecdotally he has access to. We think when it comes to the data that would be presented out of the Auburn location, his experience would be reflected by that data, yes.
Thank you. And is it your position too, again, just for in an abundance of clarity for me, yep. Perhaps it's clear to others, but your claim is that your client didn't know about this, LIFT leadership or training program or professional development program, and never, saw any literature about it or any promotional campaign?
He understood it existed. He had no idea that it was a program, and frankly, he disputes that it was a program you could just apply for or say, hey, I'd like to participate in this. And to the extent that he was expressing a desire to advance at the company, he did everything possible to indicate that he would be a candidate for that program. And frankly, if it is legitimately a program that's accessible to everyone, it certainly would have come out in those conversations that he had over and over again about wanting to advance, that he had access to a program like that. They offered him access to a little help to fix his resume and told him, hey, your resume looks great now. If legitimately they were trying to get him into a new position, why not then say, hey, you're applying for a position that requires 2 levels of advancement. The only way you get a 2 level of advancement elevation at the company is by taking this program. Why don't you apply?
Thank you very much.
Thank you.
Well, did he ask to apply? Is this just a misunderstanding?
No, he didn't know that it was a program to which he could apply.
So it's a misunderstanding. He didn't know that it was a program to which he could apply.
I don't know if it's a misunderstanding. I dispute that it is a program to which you can apply. It seems that it's a program that folks are selected, at least in the Auburn location, folks are selected, and the folks who are selected are younger folks.
Okay.
Commissioner O'Brien.
Thank you. I'm looking at page 8. Okay, page 8.
I'm having a difficulty hearing.
Okay, nobody ever says they can't. So thank you for that.
You're welcome. Talk as loud as you want.
One little snippet, Mr. McNeil was encouraged to introduce himself to the hiring managers for the internal positions, but he never took the opportunity to do that. And also, you just suggested that it wasn't a misunderstanding. But that, is there any document, is there anything that can say, that can confirm? Just answer my first question and then I'll.
Yeah, so I think the answer to the first question is probably going to answer your second question. Exhibits C and G to our reply to the respondent's response demonstrate, one, that he did communicate with some of the folks who were offering the jobs, and he communicated with people above those to say, hey, I'm getting no traction here by the work that I'm doing.
And I guess my supposition would be, maybe I'm wrong, that in those conversations, they would say, hey, you need to seek out the LIFT program.
That's precisely our point, is that that's where they should have done that.
But
they
then
didn't.
You're saying they, okay.
Yep.
Okay, thank you.
Thank you.
Yeah.
Any other commissioner questions for Attorney Lee?
Just one last quick question. Do you know, well, you know, on page 2, I believe, of the investigator's report, the respondent offers some, rationale that, part of the reason that your client was not promoted was because some of these positions were located in other states. Did your client ever indicate at any time that he was unwilling to move outside the state of Maine to access a professional development opportunity or, another job?
He doesn't recall those things coming up, and there's sort of a secondary issue that we can go back and forth about, and frankly in the pleadings we did, is that those interviews all occurred via Zoom, and when you enter a Zoom, it says this meeting is being recorded. Each of those meetings was being recorded, yet we asked that some of these documents get produced. There's some assertions that we've made in some of our pleadings that could perhaps be proven by the existence of those recordings, but they weren't produced by TD. TD says they don't have them. In a trial, we might have a spoliation argument, but that's obviously not for the commission to resolve.
Thank you.
Thank you.
Any other questions for Attorney Lee? None. Attorney Lee will have about 3.5 minutes when we come back to you. Attorney Powell, you have 10 minutes. Do you want to reserve any of your time?
No need at the outset. Yeah. Good morning, commissioners. Thanks for your attention to this case. And I just want to say at the outset that the investigator Leva did a thorough investigation here, did a great job of reviewing the parties' numerous submissions, and reached the correct result here, finding no reasonable grounds for discrimination. Despite all the information that was submitted in this case about the internal positions to which Mr. McNeil applied, the case is actually quite simple. TD is incredibly supportive of employees who want to advance their careers internally with the bank. I work with a lot of employers, and so I say this based on my personal experience with them as much as the evidence that we provided in this case. Mr. McNeil says that he wanted a promotion from his job at the contact center, but the actual evidence shows he didn't take the steps that would have helped him to do so. He didn't work with his managers to identify interests and opportunities for advancement. He didn't reach out to hiring managers who had upcoming open positions that he was interested in. He didn't enroll in or ever express interest in the career advancement program, which I'll talk about in a minute. And respectfully, I think it's getting a little bit of outsized attention, but I can describe that a little bit more for the commissioners. Instead, what he did is he scattershotted online applications to numerous internal openings, many of which he wasn't qualified for. Now, TD Bank has a policy on opportunities for advancement, and it states this: employees submitting internal applications should focus on their career aspirations at TD Bank and should post only for those positions for which they meet the minimum qualifications. Employees should be deliberate, not random, about the positions they select. And unfortunately, that's precisely the approach that Mr. McNeil took here. Despite counsel's description of it after the fact now, that's really what was happening with Mr. McNeil's applications. When he had the opportunity to interview for 2 of these positions, he showed no enthusiasm for the roles. One of the hiring managers observed he appeared to just be going through the motions. TD received many applications for these positions to which Mr. McNeil applied, sometimes hundreds of applications. Mr. McNeil was never among the most qualified applicants, and the investigator did a great job of going through each of those positions. Look, we provided information of the other applicants and the people selected for the position. Eventually, Mr. McNeil did reach out to TD's head of the U.S. contact center, who was several levels above his own manager, pretty high up manager of the whole contact center, to say that he had applied for several internal positions. He wasn't getting selected. This was a great move. The head of the contact center is really passionate about helping contact center employees advance their careers. And we produced the emails of his interactions with the head of the contact center. You can tell he's very enthusiastic. He responds enthusiastically, sets Mr. McNeil up with a recruiter who also immediately offered to help him out, come up with a plan of action. She met with him, and the emails are in our submissions of their communications together. These individuals were genuine, and they were enthusiastic about helping Mr. McNeil out. So what did Mr. McNeil do with this opportunity? He met with this recruiter, didn't show any interest in working with her. We have an email of her contemporaneous recap of the conversation afterwards, where she says, unfortunately, he didn't want to work with me. He never followed up with this recruiter afterwards for any further assistance. And then he didn't apply for any further positions in the bank after he had this opportunity to work with this recruiter. And this is perhaps the most critical fact in this case. After meeting with the recruiter who offered to work with him, find an internal position, Mr. McNeil did not do any further work, did not apply for any further positions for the remainder of his time at TD. Mr. McNeil was never actually invested in pursuing advancement. He simply expected a higher level position to just be handed to him. And as supportive of as TD is, this isn't how it works. It's not how it works in any company. You don't just get handed advancements. So about 5 months later, November 2022, Mr. McNeil resigned voluntarily, and he sent a resignation email which stated, quote, "My career goals have changed since I started working here, and I feel that the time has come for me to pursue another opportunity that is more aligned with my interests. I appreciate the time I worked at TD, and I will remember all the time and help you gave me." There's just no discriminatory animus here. Mr. McNeil now claims he was constructively discharged. There's simply no evidence for this, as the investigator found. Also, Mr. McNeil never sought to amend his complaint so that that constructive discharge claim would be time barred anyways. So I want to respond to a few of the specific arguments Mr. McNeil's counsel is making now. First is in his objection, he states that the investigator kind of missed the forest for the trees and just looked at the specific jobs to which Mr. McNeil applied. But let's be clear, Mr. McNeil's complaint is not that he faced age discrimination in his job at the contact center. It's that he was passed over for other internal positions that he applied to. So of course we have to look at the statistics of these other positions he applied for. And of course we have to look at who was actually hired, and that data shows, as the investigator found, the ages span from younger to Mr. McNeil to older than Mr. McNeil for these positions. There's just no actual evidence of age discrimination. Second, where Mr. McNeil tries to claim that the proper comparators are actually his colleagues in the contact center who were given more career advancement opportunities. Respectfully, there's just no evidence for this. And the only thing counsel could provide was kind of speculation after the fact of what the evidence might show. Well, we went through the investigation, we provided a lot of information, and there is no evidence of age discrimination. Now, counsel is making a big deal about the TD's career advancement program called the LIFT program. It is a self-nomination leadership program, and it's for individuals who express interest in advancement by volunteering for the program. Employees participate in this program, they are not selected by management to do so. When counsel states that, it is not correct. This is not a program where managers are selecting who is involved in the program. When Mr. McNeil says this program was only open to younger employees, that is just not true. It is open to anyone, and it's a voluntary program that anyone can sign up for. Critically, counsel had to admit Mr. McNeil understood this program existed. That's really the critical fact. He knew of this program. He was always eligible to enroll in. Third, the issue about the interviews for the Zoom interviews for two positions that he interviewed for, the accounting and construction loan positions. And counsel is alleging that these were recorded by Zoom. They absolutely were not. It is not TD Bank's practice to record job interviews of applicants. And Mr. McNeil tried to introduce new allegations about what was said in those interviews, allegedly, which have been properly struck from his objection here. But the evidence demonstrates that in those two positions for which he interviewed, there is no evidence of age discrimination. In fact, for the first job, the construction loan job, the individual hired was 48 years old, within 5 years of Mr. McNeil. For the accounting job that he interviewed for, there were 3 individuals hired. One was 51 years old, only less than 3 years younger than him. And another person was 60 years old, 6 years older than Mr. McNeil. There's just no evidence that these jobs were somehow systematically being given to younger applicants. Ultimately, we've heard no actual error of fact or misapplication of the law by the investigator. So for these reasons, we ask that the commissioner accept the investigator's finding of no reasonable grounds, and I'd like to reserve any remaining time that I may have for response. Happy to answer questions from the investigators. Sorry, from the commissioners.
You'll have about 40 seconds when we come back to you.
Okay, quick.
Commissioner, questions for Attorney Powell. Commissioner Douglas.
Yes, Attorney Powell, good morning.
Morning.
So because there's been an allegation that there may have been age discrimination with respect to the LIFT program who gets to participate, I just wanted to ask you if you could clarify for us how employees are notified of this program, how do they enroll? Just walk us through the process.
Yeah, so I'm not sure I know precisely the process, but I do know that contact center employees are notified of the program. Council acknowledged that Mr. McNeil knew of the program. And it's a voluntary enrollment program. They're notified of it. This is available if you want to use it. Now, I think council is also overemphasizing the importance of that program. It is certainly not the only way to advance internally. Mr. McNeil himself, applied for other positions internally. It's not the only way to go. Another critical fact here that's, I think, important for the investigators, we provided information of, which the investigator asked, provide us all the statistics of the employees who advanced from the contact center 2 or more levels up, because that became an issue here. Who's able to go 2 or more levels up? Of the 210 employees at the contact center who were, who moved 2 or more levels up, only 10 of them did so moved outside the contact center. So nearly everyone is staying within the contact center line of business when they're advancing through, 2 or more levels up, whether it's through the LIFT program or not. Mr. McNeil never applied for a position within the contact center. All of his 12 applications were outside the contact center. So he's not, following this path that 200 out of 210 employees of the contact center were following when they jumped up 2 or more levels for these positions.
Just to make sure I understand you, we don't really know how the notification occurred, right? We don't know if it was like a poster on a bulletin board, like some of these, these sort of employment posters that you see about discrimination and things, right? You put the poster up in the employee lounge or what have you. We don't know if it was like a poster, if it was like an email that got circulated. I mean, how was this notification done?
Yeah, specifically, oh, sorry.
Yes, so the investigator is telling me that in-depth information on that program is not in the record. It was a program that was mentioned, but there isn't a ton of information about the notification process or how all of that is covered at this point.
That was going to be part of my response. Was, yeah,
Right. So if
it was
it's not in the
something
record, unfortunately, we can't talk about it.
Yeah, not something that was developed in the record. But as I'm stating, though, I don't want to emphasize too much how specific that program, how specific of an impact that program had on Mr. McNeil's prospects for internal promotion. That was not the sole way he could have advanced within the bank.
No, I understand that. I mean, I think the reason why we're exploring this question is because your opposite number has made an allegation that there was some discrimination in the access to the program. So.
Yeah, and frankly, that's something that's only come up now at this objection stage. It's not something that was, that was discussed during the investigation or investigated more thoroughly.
Okay. All right. Thank you.
Any other questions for Attorney Powell? Seeing none, Attorney Lee, you have about 3.5 minutes if there's anything else you'd like to add.
Well, let's start where he left off, which is with a patently untrue statement that it came up only at the objection phase. Frankly, this was a claim that was flagged in the reply. I didn't do the original complaint in this case, but it was flagged in the reply that there was a deficit with respect to training when it comes to older employees versus younger employees. It's a clear claim that was made and obviously investigated by the investigator by dint of the footnote 1, which says that it's non-existent. So the second issue, and I really would direct you to the record, and I don't know to what extent you have access to the exhibits that were attached to the reply. There was an assertion made that Mr. McNeil did nothing with the assistance that he received. He received resume and cover letter assistance. There's an email in the record, Exhibit E to the reply, that's a response from, and I won't name them, an individual who provided some help that says, wishing you the best of luck, Cliff. I looked over your cover letter and made some changes. It looks great. I am also attaching your resume again with my comments removed from the borders and documents renamed. Please ensure that you submit both resume and cover letters as PDFs when applying for the job. To keep formatting consistent, I took the liberty of saving them as PDFs. Should you accept all my changes? That was on May 3rd, 2022. He then applies for a job as indicated by Exhibit C, which contains a suggestion from his current manager that he would be supportive of him receiving the role. There is also in exhibit, sorry, I'm jumping around on these exhibits, but
I can clarify things for you, Attorney Lee. The commissioners don't have access to exhibits at all.
I'll walk you through it as best I can here. So Exhibit D is addressed on May 31st, 2022. So obviously after he has received that information, it's also itself a follow-up to someone with whom he interviewed, which belies another suggestion that he never followed up with any of the individuals he interviewed with. It says, hello, the person he interviewed with. I wanted to follow up and let you know that I do appreciate you taking the time to interview me last week. I found the job description to be very interesting and would be very humbled to be given an opportunity to work in the accounting department. If I meet the qualifications, your department can use that help. Additionally, in Exhibit I believe it's in Exhibit G, but it's some ways down. We had talked about the high-level individual with whom he discussed a potential employment. This was on June 6, 2022, substantially after that communication, where he's still pursuing possibility. He says to that individual, hope you're doing well. I applied for 3 more jobs after the ATM specialist job we discussed and was passed over for the accounting clerk position. I'm fully educated and experienced to do the accounting work. He then later says, the hiring process seems impersonal and confusing. He's indicating to all people who will listen that he wants job advancement at TD Bank. This is the time that it would have been perfectly, oh, sorry. You don't have information about the program. This is the time that it would have been appropriate for someone to say, we have this program, apply for it. Thank you.
Any other commissioner questions for Attorney Lee? Seeing none, Attorney Powell, you have 41 seconds. If there's anything you'd like to add very briefly.
Go for it.
I'll sprint to the finish. Yeah. I just want to respond to one thing Attorney Lee was just saying, and I think respectfully, he's kind of confusing the timeline here, but there were multiple conversations that Mr. McNeil had with folks from the head of the contact center's office. There was some resume work that they did with him. That was earlier, and then he did apply for a few more jobs. He went back, worked with the recruiter again, and that's when he had a personal meeting with that recruiter after his last applications. That was where she has an email that's in our exhibits where she describes, you know, her in detail her conversation with Mr. McNeil and her perception that he was not willing to work with her and didn't have any interest in pursuing further positions. And in fact, he never did apply from that point forward, never applied for any more positions. Thank you.
Any further commissioner questions for Attorney Powell? Seeing none. Thank you both. And next we'll hear from Nupur Leva, the investigator assigned to this case.
Good morning, commissioners. I hope everybody can hear me okay. I honestly don't have a lot to add. That's not in my report. I understand that there's been a lot of mention about the LIFT program. As Kit mentioned earlier, I didn't get into that in depth when I was doing my investigation. I was provided little information on it. I stuck to that information, but I focused mostly on the positions that were applied for and who was hired for those positions as part of the age discrimination complaint. It seemed mostly that that's what the complaint was focused on. So that was where most of my focus in this case went. I'm happy to answer any questions that any of the commissioners have.
Commissioner Douglas.
Yes, Investigator Leva, good morning.
Good morning.
Let me ask it this way. Is there any data in the record bearing on the question of the ages of people that participated in the LIFT program?
No.
Thank you.
Good question. Great. Any other questions for Investigator Leva? Seeing none, thank you, Nupur. We've heard from the parties and the investigator. At this time, we'd be looking for a motion. There is one proposed finding.
Yes.
Okay. I make a motion to accept the report. There were no reasonable grounds to believe that TD Bank discriminated against Clifford McNeil on the basis of age. and the complaint should be dismissed in accordance with 5 MHRC.
Section.
Section, yes, 46122.
Second.
Thank you. It's been moved and seconded. Any discussion?
It would be very helpful if there were facts in the record reflecting the method and manner in which employees can self-nominate into the LIFT program, and then of course related data as well, and consistent with plaintiff's argument that there is some evidence, right, of age discrimination with respect to who accesses and ultimately is given, access to that particular training program. So just an observation about that.
So since you said that, right, I guess what I would say, I hear that and I appreciate that comment. And I found myself thinking that same way during this hearing. I think also, however, there is evidence in the record that the respondent worked with complainant, there was a recruiter, there were discussions about career advancement, there was like a process where they're trying to work with him to help him, achieve his desired goal. And so I think that in terms of in the context of an age discrimination claim, I think that's pretty convincing.
I think his resignation letter just says his interests have changed and he's moved on. That's hard to reconcile with sincerely held belief that he has been discriminated against by the employer.
And I understand this does frequently happen, that things are brought up at the hearing and commissioners would like more information about those things that are not in the record. I just want to remind everyone that the investigator reviews the file, but our commission counsel also reviews the file. So if that information had been necessary during the course of the investigation, somebody probably would have flagged it. As frustrating as it is for you all not to have access to the whole file, I also sometimes don't want you to have to read several thousand pages of submissions, which I think you probably appreciate. So we try to strike a balance as best we can. Yes, yeah, you've got enough to read already. All right, so it's been moved and seconded. Any further discussion? I remind myself where I am in this process. Okay. Seeing none, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
Yes.
Commissioner Walker?
Yes.
Commissioner Sanders?
Yes.
So the findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and the council confirming the results of the hearing. I need to stop.
The next case is E22-0329 ABCD Sharon Picard versus Town of Madawaska. And the recommendation is for no reasonable grounds on both counts. We'll hear from complainant.
You're on Zoom.
All right, good morning, Ms. Picard. You have 10 minutes. Do you want to reserve any of your time?
Yes, ma'am.
How much would you like to save?
Whatever I have remain. I'm gonna go and then whatever I have, I'll reserve.
Great.
I'm sorry.
Whenever you're ready, go ahead.
Thank you. Thank you for having me here today. I wanted to go over some of the factual inaccuracies of my case. The first that I found was that the investigator stated that the first report of sexual discrimination.
Oh, you're muted.
I apologize. I just hit my space bar.
Okay.
The investigator stated that the first day of sexual discrimination was June 2nd of 2022. It was actually first discussed with the town manager in April, and then at least 2 more times in May of 22. Specifically in May of 2022, I spoke with the town manager in the building where I worked regarding a lack of support from him regarding subordinates not following instructions. And I was told specifically not to reprimand the employee because he was too important to lose to the department. And I would just have to accept that in past practice, he could do what he wanted. The town manager
The second inaccuracy was that the town manager requested the Board of Selectmen chair investigate the official report. That is incorrect. The town manager actually wanted to investigate my official reporting of sexual discrimination with HR and myself. I declined that meeting. And then the Board of Selectmen chair, when he first met with me, stated that he contacted the town attorney upon receiving his copy of the report. And then he was given the option to either investigate, which he admitted he had never done before, or hire an outside investigator. The investigator also notes that the chair reported stating 6 weeks into my employment, concerns were raised. That would be the same time period that I started going to the town manager and stating my concerns about insubordination. During our June 2nd meeting, the town manager had stated that he had great faith in me and that I could run the recreation department without a doubt. And during that meeting, again, I reinstated the fact that I was having difficulty with male coworkers, other directors, and also subordinates, which he declined to even address and say that we need to work together better, or to those words. The investigator omitted any mention of my meeting with the town finance director regarding hiring independent contractors, or even noting that I had hired an independent contractor in the past. The investigator concluded that nepotism was a reason for my dismissal and not the actual reporting of the sexual discrimination or hostile work environment. The town policy did not name children in their nepotism policy, and that was actually backed up by the unemployment hearing officer as well. The other fact was that I had hired my daughter as an employee at the town of Madawaska, which I had not. I had filed the paperwork for her to be an independent contractor. And when told that they were uncomfortable with paying her, or that they felt it was illegal to pay her, I immediately told them, do not pay her. We'll cancel her future classes. And my husband and I will make payment to her to keep that open.
Oh, you're muted again.
Relevant facts that were submitted during the investigation but were left out of the report. I feel that the Board of Selectmen chair failed to investigate the substance of my the investigation to my complaint completely. I was recorded in my interview. None of the other participants were. When I asked about that, I was told it wasn't necessary. I asked whether the investigator had shared the audio, the Board of Selectmen chair had shared the audio. I was told that wasn't something he was going to answer. Upon reviewing the notes I had submitted, stated that the internal investigation had slowly turned on an investigation of me and working with me rather than my complaints of the sexual discrimination and the hostile work environment. I don't feel that that was at all addressed. The fact that coworkers or directors that I worked with had characterized me as snippy and referred to me as unstable waters. My subordinate had stated that he felt that I had a female issue during the formal investigation. Referencing the June 29th meeting, again, overlooking the aspect of the Section 5 and the policy stating that nepotism does not oversee the child. The fact that I filed a complaint against the town manager on the 28th, I got the response back that there was no finding of any sexual discrimination or hostile work environment. I was then terminated the next day for the supposed hiring of my daughter to teach a gymnastics class after several other incidences where the HR director and the town manager tried to, as they say, hang paper and come up with instances in where I looked to be subordinate and making decisions unilaterally that I did not have to make. So those are just the issues. Thank you.
About 4 minutes left. Any commissioner questions for Ms. Picard? Okay. Commissioner Sanders and Commissioner Davis and Commissioner O'Brien.
Thank you, Ms. Picard, for hearing this morning. I'm curious about the hiring of your daughter. So a couple of things. One, even if it's true, right, that you did not violate the town's nepotism policy by retaining your daughter to teach a class, wasn't there a finding though that decision of yours violated Maine state law with respect to child labor? Is that right?
There was no filing. Actually, the Unemployment Commission appeal hearing that I had found that he did not find that there was enough to negate, to state that my daughter, actually, I can read it to you.
Is that in the record?
It is in the record.
Yes, that is in the record.
Yeah, it states that Officer Gagne clarified that my daughter did not fall under the criteria of being a mother. Instead, she provided short-term service by teaching 4 classes without ever holding an employment status with the town.
Slow down and read that again, please.
Sure. Instead, she provided a short-term service by teaching 4 classes without ever holding an employment status with the town and was not hired for a formal position. And that was the unemployment appeal hearing officer. And when they told me that they were uncomfortable with having her even as an independent contractor, my immediate, and I submitted this during an audio tape as well, my response immediately was, don't pay her. My husband and I will make her whole, and I will cancel the classes for next month immediately. To which the town manager said, we've spoken with our town attorney, and he has said, no, we will pay her.
Can I ask too, Ms. Picard, in hindsight, even if the policy itself didn't articulate, right, the hiring of children as prohibited, do you see that decision now as an error in judgment?
In the position I held, no. In the fact that I had then hired her as a volunteer for the summer rec program, which the town had no problem with her as a volunteer under my purview. It's a small town. Employment is hard to gather. I had a direct peer who was a director whose grandson worked for him. They circumvented the system by having me pay him out of my budget, and then I built his department. So in that department, no, I wouldn't have a problem having her because the past director or program coordinator at the rec had hired her own children, it was not policy, it was practice. So looking back now, if you asked me if I had things to do, it's hard because the program was highly successful. We had 28 children who were introduced to something they had never been introduced to before. But it cost me my job. It cost me, I mean, I no longer live in the town. It cost me everything. It cost me my career up there.
Thank you. Commissioner David.
You mentioned a meeting in which somebody said you have a female issue. Would you remind me about what that was and
certainly
flesh that out a little bit?
I certainly will. That was during the official investigation held by the Board of Selectmen chair. I'm sorry, past Selectman chair. He resigned his position. And he was doing the internal investigation of my initial complaint. He had handwritten notes, and they were admitted into the record, that were from my peers. It was a director of public works who stated that I was snippy and I had an unstable waters about me. My direct subordinate, who I had gone to the town manager and said, he is not listening to me, he's not following my directions, he's doing what he wants. I want to do something. And the town manager said, we can't do a written, he'll quit, he'll go find another job. We need him to stay. Stated that I had female issues.
Thank you.
And that I was controlling.
Is there any other discipline of you in the towns?
No, sir.
Okay.
I think I'm okay at this point.
Any other commissioner questions for Ms. Picard? Seeing none, Ms. Picard, you'll have about 4 minutes when we come back to you. Attorney.
Thank you.
Morning.
Good morning. I'm John Hamer, attorney for the town of Madawaska. So this is a case that's really about the method about Ms. Picard's termination. And it really does hinge on the issue with hiring her child purportedly as an independent contractor. And I'm happy to answer questions at any time because I think that's usually more effective. Ms. Picard was hired as the director of Parks and Rec, and she ended up working for the town for about a total of 5 months before she was let go. She was in her probationary period when this all occurred. So we can go into the investigation if you're interested, but I think the more important information right now is that Ms. Picard had her 13-year-old daughter teach a gymnastics class for the Parks and Rec department. Less than a week prior to having her do that, she submitted the summer staff list, which did not include her daughter, to the HR department. She and HR, through correspondence, discussed the need for work permits for some of the hires because they were under 16. So 14-year-olds, 15-year-olds, 16-year-olds require permits before they can work. 13-year-olds by law cannot work. We believe that she understood this, and that was why she tried to have her daughter perform services for the town as an independent contractor. Now, there's a lot of steps going in to determine whether a person can actually be an independent contractor. And in this case, there's absolutely no way she would have qualified. But that aside, the issue was that Ms. Picard hired her 13-year-old daughters and had her work. Now, the town did end up paying work because we decided that it was appropriate if she did do the work. And so that wasn't an issue. The issue, though, was the exercise of board judgment in circumventing HR to bring on her daughter as a quote independent contractor.
Since you said it was okay to interrupt.
I'm actually going to, because I have
Because you
Mr.
can't keep
Hamer
time?
is on time.
Okay,
Yes,
right,
so,
all right. You're right, I'm sorry.
yes, I can't be stopping and starting all these.
Sorry. I wanted to roll with you, man.
We'll pick up in a minute.
Is that right?
So all right, so she submitted this paperwork to the town. That was the timing correlation was because that was when she submitted the paperwork to the town. She submitted the paperwork to have her daughter paid by a purchase order for a vendor. And that's what keyed the town into what was going on, and the town looked into it. In terms of, from my point of view, the most serious issue was the age. The town's personnel policy does have a provision on nepotism, which is in the record. And I'll read it very quickly. It says that the town shall avoid nepotism as much as possible, but in no case shall a mother, father, or spouse be hired. So it doesn't specifically mention children, but it does specifically mention it shall be avoided to the extent possible. And we believe that a reasonable person would understand that hiring your child in these circumstances would violate this policy. In Ms. Picard's reply, she had raised a couple issues that I'd like to discuss quickly. She said that she did consult with the finance director, and the finance director was really not the right person to talk about independent contractors. The finance director may know about the procedures for the mechanics of granting, of issuing a purchase order, but it should have been the HR department. And if it had been brought to the HR department in the first place, this whole issue could have been avoided. And the second, Ms. Picard argued that the town actually knew her daughter was teaching the class because the HR director shared a Facebook posting from Parks and Rec, and her daughter was listed in there. But the HR department director indicated that she didn't actually review the materials. As she does multiple times, she goes and shares town events that are going on to get social media presence. So our contention is first and foremost and only that Mrs. Picard was terminated because of the decision to hire her daughter in any capacity. And we believe that was illegal under state law, and and she was a probationary employee, and we didn't think that it was appropriate to continue her employment. So now I'm happy to take questions.
Tom's first, but.
Okay, Commissioner Douglas, Commissioner David, and then Commissioner Sanders.
I think he kind of addressed first question I was gonna ask, because you said that she circumvented HR. And I was just looking for a little more detail about that. So she brings her daughter on, she's gonna teach these classes or this class or whatever. And she's talking to the finance person, I think you said, she's not talking to HR. Is that the gist of it?
That's correct.
Yeah.
There had been discussions just a week prior with HR about who the summer staff would be. And her daughter was not listed on there. She could have been, and then would have been caught and said, wait, your daughter's 13, you can't do this. But instead, she decided to go the independent contractor route, which was a choice of itself. But that completely circumvented HR. There were no discussions about her having her daughter do this class. And instead, she had her do it and then presented the paperwork after the fact. And that's when the town took action.
Okay. I thought I heard Ms. Picard say that there was another town employee that had hired their children, right? Child, right?
Grandchild.
Yeah.
I'm not sure if that's in the record or not. I mean, there's nothing illegal about hiring children that are 14 and over. So I am not familiar with any situation with someone under 14.
Right, but this would be relevant to the nepotism, right? If it's her grandchild, she's a town employee, so.
Well, like I said.
Yeah, it's been, do we know if that's in the record?
Carrie, is that in the record?
I believe the complainant did make some allegations along those lines in the record, but I don't believe there was any actual evidence submitted.
Was it an allegation?
The allegation is in the record.
So I think he can address
All right, so nepotism was certainly one part of the issue. The more important portion from my perspective was the fact that daughter was not eligible to work under law. But either way, it's not appropriate for a director of a department to go and hire family members, especially in such a circumvent manner. If she had said, I want to hire my daughter who's 14 and get a work permit, brought that to HR and HR signed off on it, that would be a different story.
And then finally, the investigation into complainant's allegations that the male employees weren't listening to her, right? So, you know, she's giving orders on a whiteboard or however she's doing it, and they're not doing that, but they're taking orders from other male supervisors or what have you. And I gathered the town's response in part was, this is how we work. Like, we have a collective environment, we all help each other out. I was curious, maybe I missed it in the report, about the part where they're not doing what she asked them to do. What's your take on that?
Well, at one point, the select board chair did do an investigation to find out and what was going on there. And he did decide that there was some communication issues, and he recommended that people work on their communication skills. So I'm not sure if that was part of it. But the town manager had testified and provided, I don't know if it was right or not, but indicated that the way the department had always worked is that members of Public Works and Parks and Recs were basically fungible employees, and they would be assigned where they were needed. And sometimes that word didn't get back to Ms. Picard. Sometimes there was some questions about whether the employees were getting the whiteboard assignments. I think that I read something in that report about that. But the town has always used these employees interchangeably in order to go where needed. And there was clearly a communication issue, but it wasn't based on gender.
All right, thank you.
If it wasn't based on gender, why does the town employer tell her that she has a female issue?
Apparently that came from one of the subordinates, and I don't know why they thought that was the case.
Aside from Commissioner Douglas's question to you just now, I was struck by the fact that your entire presentation is on the employment of the child issue, and you didn't address at all the sex discrimination case that she makes. And I'll tell you that I'm thinking that the employment issue is a pretext for the firing. She says, okay, forget about it. What do you make of that? Forget about paying him.
I'm happy to go into the sex discrimination investigation that was conducted.
But what do you make about her saying, okay, forget about it, we'll pay her ourselves?
That was irrelevant. The whole point was that she hired her 13-year-old daughter and didn't talk to HR about it, and it was a violation of law to have done that.
And so that's a justification for immediate termination.
For a probationary employee, it absolutely is. Someone who exercises that kind of poor judgment as a probationary employee who's been there for 5 months.
Okay. There's an unemployment hearing, and a hearings officer makes a finding that the discharge was not for cause, and she gets unemployment. Is that not the case?
Well, the unemployment hearing would be to determine if there was misconduct. So it's a different.
Well, you're
standard.
saying there's misconduct.
Oh, yes, I am saying there's misconduct.
So the unemployment, so the commissioner got it wrong.
Absolutely.
The
In my
unemployment
opinion,
hearings officer.
yes, in my opinion, unemployment hearing.
Okay, thank you.
Any further questions?
Sanders?
Yes, thank you. Just to help you out a little bit, the standard to demonstrate misconduct under the unemployment framework is different from, right, the standard that an employer would need to show, right, to demonstrate legitimate, non-discriminatory motive for in support of a termination, correct?
Yes.
Right. I want to follow up on one of Commissioner David's questions to Ms. Picard. Apparently, right, embedded in these investigators' notes are some pretty provocative comments, right, about Ms. Picard specifically. There was some reference to she's snippy, fine. There's some unstable waters there, okay. But this concern, this turn of phrase, female issues, that really struck me. And I wonder, from your perspective, is that a fair characterization of what appears in those notes? And if it is, what did the town do about it, right? It would have had that information. That's troubling, right, on its face. And I wonder, like I said, what did the town do with the employee who articulated that sentiment?
Sure. I don't know.
If it's in the record. If it's.
I'm not sure that it is in the record what exactly happened, but I do know that and it's in the record, that the select board chair did an investigation because part of Ms. Carr's claims were against the town manager. He went and he interviewed a variety of people to find out if there was any gender-based discrimination going on there, and he determined that no, there wasn't. That was his finding. I believe his notes are in there. I'm not sure how much of a report he wrote, but he found that it was not gender-based, but that the department, everybody could use some training and communication. And that was the result of the investigation. Now that all had nothing to do with the reasons for termination. And that's why I focused immediately on the reason for termination, because the only adverse job action that was taken was the termination. That was why I went there first.
Although, I'm going to press you a little bit on this, I know you expected me to, which is, this expression, if it's, and we can ask Carrie as well, the investigator, if that is embedded in the notes, right, from the investigation, doesn't that suggest to you that there's an attitude afoot about Ms. Picard on the basis of her sex, and perhaps, right, some of what she was experiencing, sort of setting the issue of her termination aside and the rationale for that, isn't that evidence that she could be experiencing sex-related discrimination on account of, what she was experiencing in the workplace?
Okay, so that statement was apparently made by one of her subordinates.
Sure.
In the course of the investigation, and probably the chair asked what's going on. So yes, that's not a great statement, and it may
Not only is it
display.
not great, it's wildly inappropriate, right?
It is, but you can't, I don't think it's fair to take that one statement made by an employee, a subordinate, and then apply it to everybody in town management. If there had been more issues like that, if there'd been more statements like that, then the decision, the investigation would have gone a different direction. So yeah, there's one bad statement, but that doesn't mean that she automatically wins and proves that there's a sexual harassment situation going on here. The primary issue was concerned that other department heads weren't listening to Ms. Picard. And there was no issue with any of their statements, and the town manager, and there was no issue with any of the things that the town manager had done. So I'm gonna say just one bad apple isn't gonna spoil the rest of the apple cart. I'm not sure if that's the right.
I get it.
The apple barrel.
Yeah, the barrel.
Okay.
What did the town do with that employee who made that statement? Was there any re-education, retraining? Is it in the record?
If it's in the record, I
No,
believe
he's
we,
saying it's not.
yeah, I
It's
don't
not in the
think,
record.
I don't think it's in the record, and I.
That
think
is not in the record. I'm sorry, I couldn't find my unmute.
Thank you.
If this is in the record, do you know how many employees directly interacted with, that she had regular interactions with? And because I guess I am troubled. I think I'm agreeing with you, that I am troubled that she's saying this is sex discrimination. Why that, yes, that's an inappropriate, very inappropriate comment. But if she's interacting with, it appears as though she didn't agree with other employees, and I don't see, tell me, well, maybe they're not, what else was there? I mean, I can't get it to the sex discrimination. I know I'm not clear, but.
All right, so I'll try to explain. I believe that there were 2 employees that worked under Ms. Picard.
Okay.
And Ms. Picard was one of 4 department heads. Public Works, Parks and Rec, I'm not sure who the other 2 were. And so they all worked together, and then they all worked together with the town manager. And the town manager explained to Ms. Picard early on about how the use of employees was in the town, is that basically if they needed her 2 employees to work somewhere else, that's what they were going to do. And I think that Ms. Picard didn't like that. I think that she felt she was the department head and felt that things should run differently. It comes down to, I think that's it.
When Ms. Picard went to the finance director instead of the HR director to talk about the hiring of her daughter, did she disclose explicitly that that was her intent? She was going to hire her daughter?
I don't believe so. I'm not certain, but I don't believe that her daughter's age ever come up either. I believe it was more a discussion about the mechanics of how to get a purchase order.
Thank you.
Any other questions for Attorney Hamer? 5 minutes left when we come back to you.
Okay.
Ms. Picard, you have 4 minutes and 2 seconds left if you would like to add anything.
Certainly, I'd like to just talk to a couple of things that Attorney Hamer stated. He keeps saying that I circumvented HR. That is absolutely not correct. I submitted a list of summer workers who were going to need paperwork filled out for the summer rec program. That is correct. The program my daughter ran for gymnastics started beginning of June, whatever weekend that was, the first Saturday, and it ran in the mornings. I had told HR that my daughter was going to be a volunteer for the summer rec program because I could not hire her as a camp counselor. Should she attend the training the town was giving? I was told yes, she and the other 2 volunteers should attend the training, so that she knew that my daughter is not of age. Second of all, the town manager is the one that told me to go to the finance director regarding hiring an independent contractor. The statements about the unstable waters and that I was snippy was actually a director of public works. It was not one of my subordinates. He refused to have any conversations with me, often not answering my calls to a cell, calling the office phone when I requested they call a cell phone I had on me. During the investigation, which actually the Madawaska submitted the attachments 011 through 016, which are the notes. So if Mr. Hamer is questioning whether they're in the record, they are. The town manager at the time stated that he no longer felt comfortable working with me and would not meet with me alone. So these things all happen. Then the town finds that there's no basis for my claim. And then that is what happened. But my two subordinates, one of which that said the female issues, the whiteboard's in their room where they meet every day. And with the past director, they met with him every morning and went over and explained where they were going to be and what they would do every day. For me, they would not do that. I would have to chase them around town to find out where they were in the morning. They would not meet with me. So those are just a couple points I wanted to flush out. Thank you.
Commissioner O'Brien and Commissioner Douglas.
Thank you. Could you, one of in the investigative report, it says that about 6 weeks into your employment, members of the public began complaining and whatever, can you speak to that?
Unfortunately, I cannot. That was never brought to my attention at the 6 week point. That was brought to me, I think, June 2nd, kind of as a whole bunch of things. I will tell you the 6 weeks corresponds to the meeting in May that I had with the town manager stating my frustration with my subordinates not doing the work that the rec department needed. The past Board of Selectmen chair, once I filed my report, I was CCing him on things that were not getting done, work that was always done, that was blatantly being disregarded. And I was told, it's rainy, they'll get to it. Always an excuse. So I don't know what the public complaints were at 6 weeks. They were never brought to my attention.
Commissioner Douglas.
Yes. Ms. Picard, I just want to go over the timeline with you in June. Okay, so
sure. Based
on something you just said, so I think you just told us that your daughter started teaching this gymnastics program at the beginning of June, right? Around June 2nd, I think you said?
Yeah, I could get the actual date for you. It was the first Saturday of June, but yes.
Okay, so the first Saturday of June. And
which
then
would have been the 4th.
Okay, all right. Somewhere in between the 2nd or the 4th and the 5th, right?
Yes.
And on June 9, you file your complaint alleging that people aren't doing the work that you're assigning and et cetera, et cetera. Is that
yes,
correct?
That is correct.
When did that, and I understand the investigation, the town claimed that your allegations were unsubstantiated. When did you learn of that? When did the town tell you that they concluded their investigation and they didn't find anything?
I believe it was June 27th. I believe it was June 27th.
Okay. And then on June 25, there's this email correspondence between you and the chairman regarding an email that the HR manager had sent about bathroom facilities, right?
Yes.
You know what I'm talking about there? All right.
Sure.
When do you contend that the town knew that your daughter was being hired and that she was underage? When did the town have that knowledge?
I spoke with let me back up. We sent out a booklet in May with the programming for the summer, just to kind of frame it. In there is a description of the gymnastics class, all about my daughter, her qualifications, sent out throughout the town. She started on probably that, I'd had a conversation with the finance director, sorry, prior to her starting the class, and was told independent contractors or the purchase orders go in after the work is completed. That's why the whole timing.
Yeah, let me just stop you there. So
Sure.
What I'm curious.
When did the town find out?
What I want to know is, when did the town definitively know, in your opinion, that this person that was going to be teaching this program was your daughter and that she was 13? When did they have all that knowledge?
The HR director would have known the week of the 6th.
And would have known because you told her? Or
Yes,
him?
because we were talking about summer recreation for the town, and I was trying to figure out if my volunteers needed to attend training.
And you're saying the finance person would have known that?
Nope, that would have been the HR director.
HR director, I'm sorry. Okay. All right, and then this allegation, this business about your daughter being underage and being hired and you violated the law and all this happened at the end of June, correct?
That was, yes, I was first made aware, I believe, the 28th of June.
All right, thank you.
Any other commissioner questions for Ms. Picard? Seeing none. Thank you, Ms. Picard. Attorney Hamer, you have 5 minutes and 18 seconds left.
Thank you. Okay, so after about 5 weeks, when Ms. Picard had been employed by the town started receiving complaints from the public and from other people in town saying that she had some performance issues. That was the reason why the town manager first met with Ms. Picard, and that happened on or around June 2nd. It was during that meeting that Ms. Picard first started complaining that people weren't listening to her and alleging that it was based on her sex. It was about a week later, on June 9th, that she filed the written complaint, which resulted in the investigation, which included complaints about the town manager as well. And that resulted in the investigation that found there was no, it was unsubstantiated. Now, the town was not aware of Ms. Picard's daughter's age until about the 27th or 28th, when it took action. Ms. Picard said that she was having her daughter as a volunteer, but what she ended up doing was not having her daughter as a volunteer. She was having her as this alleged independent contractor. It was not until that paperwork came back to the town manager on the 28th that it was discovered that she was actually being paid for her work, and it was acted upon immediately. So that was the time.
Yeah, so I think this timeline is problematic. I mean, Ms. Picard says that, I mean, I understand you say differently, but Ms. Picard says the town knew that her daughter was underage and was going to teach this program as of June 6th, right? And she files her complaint on June 9, and the investigation goes through and it's unsubstantiated, right? And then at the end of June or beginning of July, whenever it is, she says it's June 28th. All of a sudden, this issue with her daughter, which she says they knew about since the beginning of the month, is now brought up and she's terminated. Now, I understand that your take is different. I understand that, but based on her account, that's problematic. What do you say to that?
I'm saying that there's no evidence that the town knew that her underage daughter was going to be performing services for the town on June 6th. And
Okay, so if I'm putting this case on a trial, right? I'm representing Ms. Picard here. I guess from what I gather from her, I'm gonna put her on the stand and I'm gonna ask her, like I just asked her, when did the town know that your daughter was underage and was gonna teach this program? And she's gonna say, it was June 6th. Well, how did they know that? Because I spoke with the HR director on June 6th. That's the evidence.
it is, and
Yeah.
Is that what she said?
Yeah, that's what she said. You want
Yeah, well,
You
please.
asked the question of her, when did the town know that you were hiring your daughter? But you didn't say her age, you didn't say and knew of her age.
I did. I absolutely did.
You did?
I absolutely did.
You did it.
100%. I did not ask her, I did not
Okay,
ask if
okay.
she was being paid. Now that I agree with,
Okay,
but I absolutely asked her.
all right.
When did they know that she was gonna be teaching this class and that she was 13? That was my question.
What's the town afraid of, that she needs to be discharged? Assuming that she's a valued employee in the height of the summer season, Parks and Recreation, and she's instantly discharged within the day of that coming. If it's not a pretext because she's a troublemaker that's made a complaint about sexual harassment.
Well, there was a number of complaints about performance leading into it, and that was the very first meeting on June 2nd, was to discuss performance issues. And it was during that meeting that she started saying that I've got these other issues.
Is that documented in the town disciplinary?
Yes. Well, there's no discipline. It was a non-disciplinary meeting to discuss her performance. It was a kind of a mini performance review. In public entities, you've got, the first 6 months of your employment, you are a probationary employee. So during that first 6 months, there's a fair amount of scrutiny on your performance, on your personality, how well you get along with others, how well you perform the job. And then at the end of the 6 months, typically a decision's made whether to retain that employee before they get full cause protection.
Okay. And she says part of the performance review includes the town's attitude of being unstable, snippy, and having a female issue. And that's how, and you're describing that as how she gets along with others.
I'm just, the female issue comment was made by a subordinate in the context of the investigation. That was not a feeling felt by the other members of management.
And our standard is whether it, as likely or not that she could persuade a jury.
The employee who made that statement had no decision in the termination. They're a subordinate. They're not part of management. So
they're part of the town.
Well, they are, and
okay. I got it. Thanks.
Commissioner Walker.
I'm going to go back to one of the statements you made earlier regarding the definition, I think, of an independent contractor. And I think you said that there is no way that her daughter would qualify under state law as an independent contractor. I want to take that one step further. Is a department head, especially a relatively new one, authorized to make that decision or that determination?
Probably not. That's a question that should have been brought to HR. She wasn't fired for miscategorizing her daughter as an IC instead of an employee, or she was terminated for ignoring the child labor laws, which she was provided. And she knew that in order for someone under 16 to work, they had, if they're 15 or 14, they had to have papers, and that under 14, you just can't work. That was the problem.
So once again, we have 8 or 9 cases on the hearing agenda. It is 11:37. We have 2 more cases before we break for lunch. So it's your assertion that she had actual knowledge of the fact, right, under state law, if she were to hire a minor, that minor had to be at least 14 years old, with a permit and so on and so forth, correct?
Yes, because she had actually discussed the summer hires with the HR department head about a week earlier. She's been provided a state poster that provides you the standards. So we believe that she knew that someone 13-year-olds couldn't work, and so she tried to circumvent it by having her work as an independent contractor. The statute actually says you shall not allow them to work or suffer to work, so I think it's broad enough to cover anyone who's 13 couldn't be working.
Thank you.
All right.
Further questions for Attorney Hamer?
Got 6 or 7.
No lunch for you, no lunch for you until we finish the morning session.
Deference to you, I'm going.
Thanks, yes, I appreciate it. All right,
So
many
thank you, Attorney Hamer. We've heard from the parties. Next, we'll hear from Carrie McCarter, who's the investigator assigned to this case.
So I think I'll just clarify a few things. I don't want to get too in the weeds. Just as far as April and May, and allegations that sex discrimination was particularly broached. There was an ongoing issue involving a gazebo and who was in charge of the gazebo. The complainant felt that they should be involved in these discussions. They were told, no, this isn't your area. I don't recall in the record that complainant specifically alleged during those gazebo-based meetings that there was some type of sex discrimination going on there. As far as what was brought up with unemployment and the unemployment hearing, this does come up occasionally, based on what I recall from my prior tenure with the commission. We generally just point out that that is not relevant to us in that their standard is not at all similar to our standard. So their findings really have nothing to do with our ultimate recommendation of reasonable grounds or not. See, as far as I do understand your concern about some comments that were made. I addressed the word bitch being used, which the complainant had not reported, but was submitted during the course of the investigation. That the single one-off comment would not rise to the level of harassment. I would say the same for the female issues and the unstable waters. Just to give you a bit more context for that, there were a total of 6 interviews in this investigation, in the internal investigation. I have 16 pages of notes from those investigations. There were many concerns expressed about the complainant's various behaviors. So that was not the majority of, that was by far not the majority of what was found during the course of the investigation based on the notes that I am looking at. And I could provide some examples if you want me to get into that. You asked about the I think the standard practice for employees to work together. I did address that. It is on page 3 of my report. Very first paragraph E. PNR employees did not listen to her because she is a woman, and other department heads assigned PNR employees work without her permission. Town manager explained that this is standing practice for all employees to assist other departments, and that this practice will continue because the team approach to work is in the town's best interest. This was never refuted by the complainant, that this wasn't standard town practice. Among the interview notes that I have, there was also mention of this practice, and that it was ongoing and they hadn't been informed to handle things otherwise. I think as part of the conclusion of the investigation, the chairman did recommend that there were meetings between the directors of the different departments to just to have more communication. So he did recognize that the lack of communication was an issue, but I didn't find a reason to suggest that this was sex-based. Let's see, as far as the age of complainant's daughter, I do think that is relevant. I have no evidence in the record that they knew that her employer should have known her daughter's age. And there's a difference about, I think, about asking about volunteering versus actually hiring someone, and the labor laws around that. Although that's kind of getting away from the our own statute. I think that's. I will let you ask whatever questions you would like.
Questions for Carrie? Commissioner Douglas.
Yeah, still morning, good morning.
Morning.
Were there any female town employees in similar positions?
There was, I believe the person prior to the complainant was a female, yes.
Okay, anybody while she was working there?
As a director?
Yeah, as a department head.
Right, so HR director. I only have information specifically about the departments that were sort of interrelated in this case, which I don't have offhand, but related to Parks and Rec. So those were I didn't ask for a list of the sex or gender of all the department heads. I don't even know how many there are total for the town. I don't know how many separate departments there are.
The people that you interviewed for the investigation, how many men, how many women?
That I interviewed?
Yes, yes, please.
I did not interview anybody for this investigation.
Oh, I'm sorry.
There was an internal, it was only the internal investigation that was done. We saw all the notes.
I must have misheard you before. My apologies.
Oh, I just what I was talking about before, as far as the interview, that was the town's internal investigation.
Fair enough. All right, thank you.
Commissioner David.
I understand that the unemployment standard is not binding on us and not necessarily relevant, but in a specific case, which I think this is, when the unemployment finding is that there was not misconduct, and when the town's presentation to us here is that the entire reason for her firing is misconduct, why is it not relevant?
Because, as I said before, their standard is not the same as our standard.
Isn't it misconduct?
I really can't speak to the labor department. That may be a question you want to address with our attorney.
Yeah.
All right, thank you.
Any other questions for the investigator? Seeing none, thank you, Carrie. We've heard from the parties and the investigator. At this time, we are looking for a motion. There are two proposed findings.
I move to accept the findings as written in the investigator's report.
Second. Right, it's been moved and seconded. Surely there's no discussion. Commissioner David.
There certainly is discussion.
Yes, I hope you all picked up on my sarcasm there.
I think that the town's firing her for this reason is the definition of pretext to discuss to cover discrimination. And I think it is a hostile work environment. She's described a complete undermining of her authority in the context of being considered in that culture snippy and unstable and having female issues. It's a tempest in a teapot, this business about the inappropriateness of hiring her teenage daughter to do a gymnastics program. She says, okay, forget about it. And for that, she's fired. That's a pretext to cover discrimination.
If I could just chime in, I mean, I think that this case is, given the standard even chance, right? I mean, I think, as I said, I think the timeline here is troubling. I think on the evidence of sex discrimination, I think as Commissioner David pointed out, the circumstances here where she's handing out assignments and these guys are saying, you know, I could do it. I understand that there's gonna be evidence at trial that there were communication issues, maybe they didn't see the whiteboard, et cetera, et cetera. But I also think that a jury could believe that, you know, maybe she got these work issues, right? She hires her daughter, she's got her daughter coming in as a volunteer, whatever it is, right? But that's early June. And, then she makes this complaint unsubstantiated, and then almost not far after, she's let go for something that they knew about, and a jury could conclude this potentially at the beginning of the month in some capacity or another. So I'm troubled by this one. I could see it going either way, but that's the even chance standard of the commission. So
I think there's two things happening simultaneously, right? One is she violated Maine law, right? You've got a director in the town, and making a decision that violates the law, right? It exposes the town to scrutiny from DOL, enforcement action. It's a reputational issue for the town. All of that. Is it a serious error in judgment? Absolutely. Notwithstanding sort of the nepotism policy and discussion around that, and at the same time, right, deeply troubling facts about the working conditions. So did the town articulate a legitimate non-discriminatory reason, right? Violation of Maine state law in support of the termination? Yes. May the town have work to do with respect to ensuring that the terms and conditions for all employees in the town are free from discrimination? Absolutely. So I'll yield the floor to.
I see Commissioner Council has appeared.
In case anybody has any questions for Barbara, here she is.
Like the good fairy of the Mason, there she is.
Any further discussion?
I just in response to Commissioner Sanders, I don't think the town's exposed to anything. They come and they tell her you can't do that, and she says, okay, forget about it, and that's before she's paid. And they say, no, we're gonna fire you for it. I don't think they're exposed to anything at all. I think it's a pretext to get rid of it. So there we go. And I agree that there's an even chance. And that's should be our statement.
I feel like Barbara wants to say something. You want to say something? Do we need to ask you a question in order to get you to weigh in?
She mutes herself.
I intentionally didn't.
Okay.
I assumed Ed was intentionally avoiding me.
All right. Any further discussion or questions for Commission Council? None. The motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David.
No.
Commissioner O'Brien.
Yes.
Commissioner Walker.
Yes.
Commissioner Douglas.
No.
Commissioner Sanders.
Yes.
Okay. The findings are no reasonable grounds. We appreciate everyone's participation. The commission will send a letter to the parties and council confirming the results of the hearing.
The next case is E22-0368 AD. You want to break?
Chair, 3 minutes.
Okay.
Would be great. Thank
Sure.
you so much.
We'll be in recess for 3 minutes.
Lunch is here if you would like to eat.
Bring the meeting to order, please. The next case is E22-0368AB, Jose Gabriel versus Abbott Lab. It is a recommendation of no reasonable grounds. We will hear from the complainant.
Right, is there anyone here for Mr. Gabriel?
I'm on Zoom. Can you all hear me?
Yes, you have 10 minutes. Whenever you're ready, go ahead.
First of all, thank you so much for your attention to this case. I think I would fully focus on the facts that I have provided to the investigator. I know that, let me just grab my notes here. Just to kind of bring back to the previous accusation that I was terminated for. I was based, per Abbott recommendation on investigation. I was terminated for aggressively assaulting my direct report, using vulgar language, and also having an intimidation communication. I truly believe that I was terminated by racial bias. The first instance that I had racial discrimination was a male and female, white male, white male, and white female that has drawn, have used the Abbott computer to draw a white man on that photo, and also 3 monkeys underneath of that paperwork. And they went around and they passed it after they have drawn that, and they passed it around only to Black employees. And that got to my attention. I have contacted HR, Helen, and also my manager, Mike Poliquin at the time, and also John Hulbert, who was from the other shift. At that time, he was present when I brought that to my manager attention. I was under, well, back then, Brian, he was under my...
Mr. Gabriel, please don't use the names of any of those individuals.
Okay, my apologies. Excuse me. So those, I brought that information to the site leader as a, those were the recommendations of the Abbott, the way to work. You bring it to your local leaders, HR, and then they'll take it further ahead. As of now, the only conclusion came out to it that site local leaders have concluded that those people that were involved in that act, they did not intend to be racial biased, that they have regretted for what they did, but no action was taken, but instead they were given a record of discussion instead. So I also truly believe that I was, the way that I was treated by the HR site lead, Helen Duckett, is drastically different than how other people or white people, Americans specifically, were treated by her and the leadership team. Also, I was not afforded a confidential investigation. When I was approached first in this case, my direct report has come to me because the person that was accusing me that I have physically attached to her, she was having conversation with other people. So my direct report has come and had conversation with me in the sense of she didn't believe what was happening, so she needed to hear from my side. I said that there was an ongoing conversation, that I could not have any further conversation with her, that if she had any issues, because she has offered what she can do to help in this case, I suggest that she go and talk to Helen. She have come numerous times.
Mr. Gabriel, again, please don't use the names of third parties. So none of the managers, none of the HR people, you can refer to them as their titles, okay, but please don't refer to them by name.
My apologies, sorry for that. The site leader, I asked her to go talk to the site leader at the time. Again, she came numerous times. I personally have gone and talked to the site leader at the moment, as she was constantly coming in. And she immediately, I did say to her, like, she was bringing certain issues to my attention, and I think you should hear her. She scheduled a meeting with my direct report, and she have had a conversation with her. After the conversation, she have come back to me and said that she have had a conversation with the site leader, HR, that she told her what was going on. She continued coming in, and I also messaged on Teams the site leader and the senior site HR letting them know that the investigation was not confidential, that the person that was accusing me, she was having a conversation with other people. According to Abbott investigation, the conclusion, they said like I was swearing within, whether speaking Spanish or French, either language I don't really speak fluently, and also it's questionable. If someone who doesn't speak those languages, how do they know that I was swearing? That was another thing that I found very interesting on my side. On the issue of swearing at work, I do not swear. I do not use vulgar language, and I do not raise my voice unless there is an immediate safety issues. So on that case, my direct manager at the time, we were in a meeting. We're involved other leaders, OPEX leader at the time. Prior to becoming my manager, he was very aggressive. He was swearing at us, and he threatened us he was going to fire us because of some things that were happening within the production environment. I personally and the other teams, we have written in an email and we send it directly to the site HR leader and copied the senior HR that worked, who supported our department at the time. All I know, my leader was coached and nothing was happening. Keep in mind that these are the actions that they claimed that I was fired for because of swearing, raising my voice, and intimidating. I had a communication intimidation. My site leader, she herself had ran into another supervisor who was yelling, screaming at employee in the hallway. And this obviously, the former senior HR have provided his statement on this case that instead of taking action, that supervisor was coached by the site leader. And it sounded as the supervisor didn't really think that he did anything wrong because, employee have said something to him and she did something different. The supervisor is a white male. The employee that he was yelling at is an African woman. The verbal coaching that was included on the final report by the investigator, I'm very aware of that conversation. There was a white male from a quality team, and I was responsible for production. There was a meeting that we had every day to address production issues. And obviously we had another team as the quality comes in and work with us alongside. This white man was raising his voice while I was conducting the meeting. He started calling me that I'm too difficult to work with. There were other leaders within the meeting, tried to talk to him to calm down. This conversation could be handled outside of that meeting. He insisted, talking to me disrespectfully. After that meeting, the other leader who was present, he decided to schedule a meeting where it included myself, his leader, and my leader as well. We had a conversation so the tables were returned in the sense of I owned the meeting, I was conducting the meeting. I became the person who was very disrespectful towards a white man because he called me too difficult to work with. Obviously, he within that meeting, he acknowledged that the way he approached me wasn't the appropriate way, should have been handled differently. I also acknowledged maybe the way that I responded, I could have done a better job. And we refused the situation and we walked along in the sense of how we can have a better communication with the production and quality team. So that was resolved. I was called by a day or two. I was called by the site HR leader. She told me that I was very, very disrespectful towards the quality team, which I found it very interesting. I asked her where she heard that from. She said like she heard it from a quality team leader, director. I said, well, she wasn't in the meeting when that happened. She assured me that she doesn't need to be in the meeting. She believes on what she said. So I found that very confusing to my side. Instead of asking what happened, she went directly accusing me of me being very disrespectful because she heard it from another person, when she wasn't really on that meeting. Or none of them was in the meeting, but they heard. It was a hearsay, per se. So It isn't clear to me how the investigator found that there was no adverse action based on a race or national origin. If he did not do any investigation outside of asking Abbott directly how they handle things. I have provided a list of people as well as a statement from a former HR business partner who witnessed this type of this type of discrimination. If they were not interviewed, then I don't know how he could come to that conclusion. How much time do I?
That is your 10 minutes.
Oh, perfect.
Great. Any commissioner questions for Mr. Gabriel? Mr. David.
Mr. Gabriel, when did you discharge the individual that you say was a friend of the complaining victim of you grabbing her?
Could you please say that one more time?
You discharged somebody in the course of your employment that you say was a friend of the woman that's complaining you grabbed her. Is that correct?
No, I did not describe that. What I did say is the person who was accusing me that I grabbed her, according to her allegation, this happened in February or January. This was only brought to my attention in May by the site HR, and investigation happened in June or July.
But I understood the investigator says that you discharged somebody that was a friend of that person that complained against you.
Yes, I was when I was first hired. I was told by the leaders that I should hold people accountable. So I did discharge the supervisor who was there.
When?
That would be in between. I do not remember exactly, but I would say it's a mid-February or March, in between that time frame. But I do not have exact date. But I would say that would be the time frame that that one of the supervisor that was there for a very long time was let go.
And how do you know that person was a friend of the complaining?
I mean, the site is only like 35 square feet, so it's everybody knows each other.
Okay, fair enough. Thank you. That's all.
Any other questions for Mr. Gabriel? Okay. Attorney Massey?
Yes, good afternoon. Thank you for your time today. The investigator's conclusion should be affirmed. Complainant has not pointed to any error of law or fact. Complainant was hired and was promoted throughout his employment without race or national origin or color playing any factor. And as the investigator's report makes clear, complainant was terminated after an internal investigation for putting his hands on a direct report in anger. And what you'll see in the investigator's report and in complainant statements today is that he has never pointed to any white manager who allegedly put hands on a direct report in anger and was not terminated. There's absolutely nothing in the record with respect to any white manager engaging in any even allegedly similar conduct. And this investigator who conducted the internal investigation, first of all, there's no evidence that he knew at the time of the investigation or his recommendation for termination that complainant was a Black man of African origin or anything about his race or national origin. This investigation was conducted by the investigator remotely, not by video. There's nothing in the record evidence to show that he had any information about complainant's race or national origin. The investigator, who was an Abbott employee relations investigator, he spoke not only with complainant, but also with the direct report who alleged that complainant had put hands on her. And essentially the allegation that she told the investigator was that the direct report raised a concern about a safety issue not being followed by complainant during a process at the plant, and that he then grabbed her chin and told her, "You're not the boss," And then he also, in the same conversation, tapped her on the chest and said something like, "You're not the boss." In addition to interviewing the complainant herself, the ER, employee relation investigator, also interviewed a witness who directly observed this interaction. And the investigator interviewed another witness who had heard about it immediately thereafter. Sorry, from the first witness. He found them to be credible. And he concluded that the complainant had put his hand on the direct report in anger. He also asked the witnesses about the swearing. And one note that the complainant made today is not accurate with respect to there being some language barrier there. The witness, and this is in Exhibit 5 to our position statement, which of course the investigator had, the witness told the internal investigator that he heard some conversation in French or Spanish, and then he heard complainant's response in English, and that the response included a swear. And when the investigator asked complainant about both the putting hands on the direct report and the swearing, he found complainant to not be credible, in contrast to his findings that the other witnesses were credible. And also, complainant could not point to any reason why those witnesses would have been biased in the direct report's favor. He just had absolutely no information to support that. The complainant never said at any time during his employment or during his meetings with the internal investigator or even during his termination meeting that he felt he was being treated differently because of his race, color, or national origin. And as I've said, he never pointed to any white manager who physically put hands on a direct report and was not terminated. As to the new information or the information that Mr. Gabriel raised in his submission, first, he said that I think he said in his submission that he had actually given some sort of disciplinary action to the direct report he put hands on before she complained about him. There's no evidence in the record that that is true. In fact, the only evidence in the record was that he had disciplined her later after the investigation was conducted. With respect to the comment about the investigation not being kept confidential, he didn't say anything about that being related in any way to his race or even that any other investigation had been kept confidential. And so it's really just not relevant in any way. And then as to whether the investigator properly investigated, we had a fact-finding conference. There were two representatives of the company. It was the employee relations investigator himself, the person who had determined the credibility of the witnesses, and then also the HR person. And I'll note that one of the individuals that complainant referred the investigator to, where he says in his submission disagreement that he referred the investigator to a HR business partner, and the investigator never spoke with that person. First, I don't know whether the investigator ever did, but also the complainant acknowledged that that person he was in a romantic relationship with for some time. I don't know if they still are. So the investigator's report and conclusion should be affirmed.
Commissioner David and then Commissioner Sanders.
Does the respondent have a disciplinary policy? A progressive disciplinary policy?
Right, there is no progressive discipline policy.
Right. It seems to me that this business about him being hired as a person of color and him being promoted is a two-edged sword. Why doesn't something show up prior to? And well, it seems to me that the allegation of the racial prejudice is in the believing of the complaining witness, the white woman, over him. If there's a credibility issue as to who's telling the truth, fueled by the fact that he says that he had to discharge, I mean, he provides a credible motive that he had to discharge a friend of that complaining witness. How do you respond to that?
I do not believe this specific point is in the record, but he did not say anything at all to the investigator about believing any allegation was related in any way to firing of a friend. So that
Our
if he
investigator
believed
says
it.
that. Our investigator says that.
Right, no, I understand that the investigator here says that, but my point is complainant did not raise that to the internal investigator. And so he certainly didn't seem to think that at the time, or didn't think that it was worth mentioning. And then as to the credibility issue, I think it's very important to recall that the internal investigator spoke to 2 witnesses, one of whom actually observed the interaction of complainant physically touching a direct report by grabbing her chin and poking her in the chest. And then another who heard about it immediately thereafter. And there's no basis to challenge the credibility of those individuals.
Well, there is an allegation that that's a basis, but that's the argument.
Commissioner Sanders? Sure. Thank you, Attorney Massey. Just a quick question about it. It sounds like, based upon what's in the report, that there were 3 individuals who would have had either firsthand knowledge or secondhand knowledge of the incident where it's alleged that the complainant, grabbed a subordinate's chin and touched her on the chest. It also appears, based upon the record, that that incident happened on or about February of 2022, and yet the report about that conduct wasn't made until June or so. Tell it what accounts for the delay in reporting, if this incident happened and is as serious as it was described, why didn't 2 individuals who were involved and then one more individual who overheard it contemporaneously, why didn't they come forward to management immediately?
And the internal investigator asked all 3 of them that during his investigation, and all 3 of them told him that they were worried about retaliation, that they didn't want to raise any issues related to employment because they essentially just don't want to, make an issue of themselves or put themselves at the center of anything, which of course I'll tell you from the company's perspective, there should not have been any concern about retaliation, but that is what they told the internal investigator.
Thank you. And also in the record too, the complainant, he notes, Mr. Gabriel notes that there should be some kind of video evidence to reflect what in fact happened in the context of that alleged altercation. Tell me more about, is there a video? In the course of the internal investigation, did the investigator review the videos, or tell me more about what's happening there?
Sure, and there's only very limited information in the record, so I think I will stick to what's in the record, which is what the internal investigator did at the time. He actually confirmed there was no video at the time. So this is when he was doing his internal investigation. He talked to security, and now I think I'm going beyond the record, but he confirmed there was none.
Other commissioner questions for Attorney Massey?
I just want to confirm something I thought I heard you say, to the effect of the internal investigator for your client had no idea what the racial identity was of any of the subjects of this investigation.
That's right. At least what I can say is he didn't recall one way or the other. There's no evidence that he knew, and all of this was done by phone. So he was never physically able to see anyone. And he didn't recall anyone mentioning their race or national origin.
Thank you.
If the complainants say the incident happened there are too many complainants here. The woman who was alleged, complains that she was assaulted, says the incident happened in February and that she doesn't come forward because of a fear of retaliation. How does the investigation get started?
Right, I think this is in the record. It actually was other female employees who complained about complainant being aggressive toward them. And during the investigation into other females, someone mentioned the direct report who was physically touched. And then the company looked into that direct report.
I see, thank you. Yeah, I think that's right, I was just forgetting.
Am I allowed to chime in?
Not at this time. Any other commissioner questions for Attorney Massey? All right, seeing none, we've heard from the parties and we will now hear from Bob Beauchesne, the investigator assigned to this case.
Good afternoon, commissioners. It seems like it's been a while. With full regard for brevity, let me just hit a few points. As was noted in March of May of 2022, HR received complaints that the complainant had an overly direct and intimidating communication style, especially with female subordinates. That led to the investigation where the female employee reported that Mr. Gabrielle had grabbed her by the chin or cheek during an animated conversation back in February, and that additionally at the end of that conversation that he had tapped her on her chest, stating that she was not the boss. As was also noted, there was a male employee who witnessed most of that interaction. The one thing I would disagree with is that that particular witness confirmed the grabbing of the cheek or chin, but did not specifically confirm the tapping of the chest. Regardless of that, that particular witness apparently had a conversation almost immediately after the above incident occurred with a third employee who described that the witness seemed to be very upset about what had occurred, and he had no reason to doubt that that was in fact a credible report. As was also noted, Mr. Gabrielle denied the entirety of the incident, denying that any such contact had took place, and largely denied that even having an argument with the individual who was allegedly assaulted. Again, based upon the allegations here, the best Mr. Gabrielle had put forward as far as a motive was again that these people who had made these statements against him were upset because he had discharged a prior supervisor. However, even assuming that that was the case, there's no implication there that that was in any way related to a protected class, his race, color, national origin, the fact that they may have shaded their testimony because they were upset about a former supervisor being let go. So in light of all of this, there was an incident, we had an alleged victim, we had a direct witness to most of the entire incident, and then we had corroboration from a third party almost immediately after the incident occurred, making that conversation almost contemporaneous as well. So based upon this, it was reasonable in my view for the respondent to let the complainant go, certainly based upon any type of an assault in the workplace, without priors, without any progressive discipline. If you're placing your hand on a coworker or a subordinate, that would appear to more than justify immediate discharge, at least in my view.
Bob, you make a strong argument. Did you interview the employee victim?
No, I did not. I simply had access to the internal investigators report. And again, in this case, had there not been an eyewitness to the event nor the contemporaneous witness thereafter, that probably would have been where I would have gone. But in this case, again, there was nothing to suggest that the investigation was superficial. Again, given the direct witness and the corroboration immediately thereafter, there appeared to be more than enough for me for the discharge decision.
You didn't interview any of those people?
I did not.
Okay, that's too bad.
Commissioner Douglas.
Yes, Bob, good afternoon.
Good afternoon.
I believe the complainant alleges that white supervisors were allowed to get away with with the same conduct, basically, right? For example, I want to take these one at a time. I believe he alleges that, white supervisors would swear at their direct reports and not be not be getting in trouble for that. And I'm just wondering, did your investigation turn up anything bearing on that question either way?
Again, that was raised by the complainant as part of his submissions. There was nothing in the record to indicate that any complaints had ever been levied against white supervisors for engaging in any type of an assault. So again, in this case, that was really, even assuming that that was the case, that other supervisors swore, it doesn't get past the fact, or at least the assumed fact in this case, that an actual physical contact took place at least once, if not twice, during the conversation that ultimately led to his separation.
Right, I'm with you on that. I was asking about the swearing though. Was there any investigation, was there any evidence that you turned up in your investigation indicating that white supervisors swore at employees and there's a different result?
There was nothing in the record to reflect that that ever occurred, nor did the complainant ever complain about that.
All right, thank you.
You're welcome.
Other questions for the investigator? Seeing none, we've heard from the parties and the investigator. This time we're looking for a motion. There is one proposed finding.
I would move that we accept the investigator's report that there are no grounds.
Second. Moved and seconded. Any discussion?
I will just say that I understand and I can appreciate how Mr. Gabriel's claims could in fact be true. I understand that. I think that where this case fails is the credible allegation that he put his hands on an employee. I think in any circumstance, if you put your hands on a direct report, you're going to get terminated. Unless there is some progressive policy, and even if there was, I think that progressive policy would have an exception for some sort of assault like that. So I think that's where this case, respectfully, I think this is where this case fails.
Further discussion?
Well, I'm troubled by the credibility issue in the face of his denials and his 2-year record of being promoted and flawlessly performing. Troubled by that.
So the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
No.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders? Yes. Findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearing.
The next case is a housing case H.30408, Kathy Sheehan versus Dowd Realty. And that's a recommendation of no reasonable grounds on 6 because of all the parties, and we'll hear from the.
Did you want to sit? I know we had talked about that.
Sure.
Yep, you feel free to have a chair. So we have 10 minutes if you'd like to give any.
When I
Yeah, I am sorry that doesn't come down.
All right.
Not our equipment.
Okay, I'm ready.
Yeah, you can move it to the side if you'd like to not have it. Microphone up higher. That should be fine. All right. 10 minutes whenever you're ready.
All right. Good afternoon. Thank you for seeing me. I'm very nervous and I'm very sick from all of this. This has been going on for almost 2 years. Everybody knows there's a housing problem in Maine. So I've been renting from him since 2016. Since that time, he has gone in my apartment without my knowledge. He's called me and said, "Did you change your locks?" he, without telling me, he has called me in the car while I'm with my mother, who's 91, saying, can you go back to your house and turn on the hot water or the pipes are gonna freeze? It's an older vintage apartment. There's no tub, there's no garbage disposal, there's no laundry facility. So anyway, throughout COVID, I did not work. He accepted 8 months of COVID rent. As soon as the rent stopped, he raised me $350 in 2 years. So I'm a single woman. I'm gonna be 65 next month. I'm disabled, and you guys were my last resort. I had nowhere else to go for help. The city of South Portland would not help me. You know, the apartment is not in great shape. I never complained to him about it. It's actually in a fluid situation right now. My refrigerator broke a month and a half ago. I collapsed because they wouldn't fix it for 10 days.
Position, apologize. Anything that happened after the close of the evidence, we can't discuss today.
Okay, and it's just ongoing issues, and so I'm here. I've done nothing to this man. He came out and harassed me in my parking spot. He came out from the garbage cans of the porch and told me, this is after he raised my rent $350. Me and you are going to be coming to an end in May. So why is this man threatening me, raising my rent, threatening me? I should have called the police. I was so scared. I'm still scared of him. I called his wife. I called the management company, and they all said, don't worry. His wife said, I'm going to call you right back. And she never did. Instead, the rent got raised to $195. So if you want me to get out, you know, if this is not retaliation, I don't know what is. It's just horrible housing situation with him. I've done nothing to him. I've done nothing to anybody in that building. I took out the garbage during COVID for 24 months because I was not working. I've only had one issue with one neighbor. I'm the third woman that he tries to push out of there, or he did push out 2 women. So that's why I'm here, and I'm very upset, and I'm sick. I have no balance in my body. So.
Great, all right. Are you?
Can I say my?
Yeah, you can say
I'll
the
say my
remainder of
time.
your time. Yep, so Commissioner questions, Commissioner O'Brien.
Thank you. Thank you for staying this long.
That's all right. Thank you for having me.
I guess I guess the whole crux.
Oh, can I say one more thing?
Let her finish her question.
The crux of this is you are maintaining that alleging that this is a case that your rent was raised, if I'm understanding, rent was raised because of your sex, familiar status, all the things that you tracked. So can you tell us we have to tie the evidence to that standard. Can you tell us why you believe you were discriminated because of those issues?
It's 2024 now. I'm a single woman. If I were a man or had a husband in my house, I don't think anybody would have been doing that to me. Coming from the garbage cans to the porch. I don't know if any of you have daughters or sisters to have them call you and say, my landlord just came and said, you're going to be out of here in May after he's taking $350 more for 2 years. I think that's a little uncalled for in 2024. I've worked my entire life. There is an error on the investigative report. It says that I missed the deadline to file a harassment complaint, and I did not, because in the footnote number 2, it says 2022 was December 2022, December 29, 2022 was when the deadline was up. No, the deadline was up 2023. So that was not looked at in the investigation. And it's, it's very confusing, the years. I get it. I'm not mad about any of that at all. I'm just, $350 a month on a retired salary, working part-time. Now, my part-time job I cannot do at the moment because I am working in an assisted living facility pushing people around in chairs and helping them, people with dementia, we go play games. I cannot work there because I can't be responsible for somebody else's health, holding them up if I can't hold myself up. So this week I'm going for an MRI on Wednesday for my body. All right, it's severe. The damage is done.
Any other commissioner questions for Ms. Sheehan? Seeing none, you'll have 7 minutes left.
Okay,
Back to you, Attorney Wolf.
Leave it up to you, but if she wants to stay seated there, I can be off the side, so she doesn't have to.
Great, it's fine with me. Just come forward a little bit. Perfect. Great. All right, you have 10 minutes whenever you're ready.
I'd like to thank the executive director and commissioners. Lunch smells great, so I try to make this brief.
I already ate.
I haven't though.
You take your time.
I'll go back to what Attorney McCormick said several hours ago. The standard of submission is to be based on relevant factual errors, relevant facts left out, any issues or questions concerning the reporter's interpretation of the law. None of that has been set forth. This is actually a case where the complaint has been given a lot of leeway. Number one, the complaint was filed against Now Realty. Now Realty doesn't even own this property. It's owned by GDR Inc. Also, I guess the one fact that the complainant said is an error is the 300 days. 300 days from October 25th goes back to December 29th, 2022. So most of the allegations, if not all of the allegations, were prior to the 300-day jurisdiction. In light of all that, the investigator did a thorough report, listed all the reasoning. I think everything boils down basically to two issues. One, rent was raised. The investigator's report talks about my client concern about rent control in South Portland, Maine. It went into effect in Portland, and they were concerned it was going to go into effect in South Portland, and the rents were well below market. That was the reason for the decision. It wasn't helter-skelter. It was done a year when she would have had her lease renewed if it had been renewed, and then done again a year later. The second issue dealt with a incident or misunderstanding, December 23rd, 2022, again, prior to the 300 days. My client had concerns of health and safety of others in the building, asked to have the fire escape cleared, went over there, and was he upset? Yes, there was cat feces and kitty litter on the ground near the entrance. He went in the building, it's an automatic lock behind him, the door locked. He has a concern for all the health and safety of everybody in there. That's why there's inspections. Combustibles on a stove or on a heater is a serious problem. The inspections done in that building were done to all the tenants. She wasn't targeted. So again, health and safety reasons, business issue in terms of raising rent. There were absolutely no facts to support the allegations of a lot of different discriminated based on race, sex, disability, familial status, receipt of public assistance. None of that was found by the investigator, and we would ask that you accept the findings of the investigator. Happy to take any questions that you may have.
Questions for Attorney Wolf?
So, good afternoon. I just want to make sure I understand this. So, she's in there, right? She's keeping her apartment in a manner which your client feels is, questionable. But really, as far as I can see, what this comes down to is, it was decided that the rent was going to be raised, right? Still not at market value, at least based on what's in the report, right? And at that point, the complainant decides she doesn't want to rent anymore and complains. Is that fair? I guess what I'm getting at is, if she had said, God, my God, this rental raise is gonna break my back, but I'm gonna stay here. I mean, would she still be there? Would that be, you know, or would your client have said, yeah, we gotta part ways?
I'm not sure that what you said originally was true. I don't think she wants to leave. I don't think she said that she wants to leave.
Right.
The rent went up because of rent control and being stuck with a very low rent below market in that area. And that was the reason the very first rent. And then it still wasn't at the right level. It still wasn't at the level of all the others in the area. So it was raised again.
Right. But the complainant has indicated she doesn't want to pay the raised rent, correct?
Correct.
All right. So if she had said, I'll pay the rent, would that be the end of the issue for your client? I mean, there'd be no more, you know, she would just be there and they would continue to sort of deal with her and the way the apartment's kept and all that sort of thing?
I don't know the answer to that. Okay. The health and safety of all the other tenants in the building is a concern and it would remain a concern.
Fair enough. Thank you.
Thank you.
Are there comparable increases to other tenants?
Hers was far below all the other tenants. When others came in, the rents were closer to market. Hers was the one that was way below market.
Because of longevity?
Because of longevity.
Any other commissioner questions for Chris? Now I feel like I can't look at you. I think I'm singling you out. All right, seeing none. Ms. Sheehan, I'm sorry, the train will do about 7 minutes left. I'll come back to you. Ms. Sheehan, you have 7 minutes now.
Fire escape has a big sign on it that says do not enter, no, except for an emergency. So there's no reason for anybody to be out there. I'm not sure, you know, why he is bringing that up. You know, I broke my hand working at Whole Foods. As soon as COVID was over, I got a job. I broke my hand working at Whole Foods. After a month, I told them on the phone, I can't pick up anything, I can't clean. My hand is broken. I can't lift more than 10 pounds. His wife cursed at me and said, get your SHIT out of our apartment. And the harassment started then. So it's just been, you know, if you read all the reports, you'll see what I put up with. And I have no money to move. I'm retired. He's getting $350 more a month. Before COVID came, I was getting raised $25 a month. So I did not create the rental problem in Maine. I'm a victim of it as a single woman. So.
Are you still in the apartment?
Yes.
And you're paying that rent?
I'm paying it. And it's causing hardship. You know, if $350 is a car payment and your insurance, I cut everything else. And it's just, I'm very upset by this. And I'm being seen by 2 different doctors from this, and it's all being documented, my health. And so this is where it's gonna be in 2024 in Maine, that a woman can get pushed around, even though she's paying her rent in a place that's not the best condition. And that's what's gonna happen here. I don't know, you know, what else to do. That's why I'm with you guys. That's why I wrote this. I waited. The incident happened in December when he came at me in the parking lot, December of 2022. I filed the complaint in October of 23. That was 300 days. I don't know why the year is so confusing for everybody. Now we're in 2024. Now I'm going into 2025.
Since we started down this road, I'm just curious, how long have you been paying this rent, this increased rent that they want?
2 years.
You've been paying it for 2 years?
Well, first he gave me $150 right after COVID. And then it went to $195 after the incident. an additional $195. Now, the woman across the hall has a studio. She's been there since 2019. She's paying $1,075. It's a big studio. She's leaving, she bought a house. She is going, they listed the apartment for $1,400 now.
Which is more than what you're paying.
Right, but she was paying $1,075.
Okay.
So I don't, I'm sorry,
Fair to
I'm
say,
sorry.
Fair to say, this is not the first rent increase since you've been there. True.
True, they were $25, $25, $50, I get it. And if he had called me after he, came at me in the parking lot, if his wife had called back and said, you know what, Bill, instead on the phone, she said, what did Billy do now? If she had called me back and said, you know what, he's having a really bad day, we're sorry, he didn't mean that, just pay the rent, I wouldn't have had a problem, but I mean, this is just ongoing emotional and physical pain right now, and there's nobody to help me.
Right, I just want to be clear about this. So do I understand correctly that what you would like us to do is, number one, find that you've been subject to legal discrimination, right? Number one. And then number two, you want us to do something about this rent increase?
Yes, and also stop the harassment. I mean, when I moved in, he said, I don't care what your inside looks like, as long as you keep the outside clean. So I just had a shade changed, I'm not supposed to say this, from 2016. Everything is the original.
Please don't say it.
All right, 2016 is when I moved in. Everything is still the same. And it's 2024 with a $350 increase in the last 2 years, so.
And the discrimination you're claiming is based on?
He doesn't like me, I'm female, I'm single.
Let me ask
All
you
right,
a
sorry.
specific question,
I'm
please.
sorry.
It's based on the condition of the apartment, right? And the rent increase, true? Some energy around those two issues, am I right?
I mean, if I wasn't paying an additional $350, I could get somebody in to help me clean. I have somebody willing to donate money to help me clean and declutter. It's just, it was 2 years of COVID in my house. Things, some of us did not work. It was really bad.
I think everybody up here appreciates the housing crisis you're
Thank you. So what am I supposed to do now? Go,
Thank you so much.
Any other commissioner questions for Ms. Sheehan? Thank you very much. Attorney Wolf, you have 6 minutes and 51 seconds. If there's anything else you'd like to add.
Nothing else unless the commissioners have any questions.
Any other commissioner questions for Attorney Wolf?
Well, I mean, going down this road that Commissioner David and I started down, I mean, there are no eviction proceedings pending right now, are there?
Or not.
And is that contemplated?
We're taking everything one day at a time, starting with this.
I understand logistical issues, but I think, yeah. All right, those are my questions. Thank you.
Thank you.
Any other questions for Attorney Wolf?
Thank you.
Thank you. Heard from the parties, and now we'll hear from Colin, who investigated this case.
Good afternoon, commissioners. As you know, I'm Colin Hurd, and I was an investigator on this case. I don't really have much at all to add to the report that I wrote. I just want to tell you that I did just now double check the jurisdiction, and it was December 29th, 2022, is the 300 days prior to when the complaint was submitted. Couple points I wanted to make. One is that I think it's important to note that the initial report of issues with the apartment, with the cleanliness and the things being stored in potentially fire hazardous areas was made by the property management company. It wasn't identified by respondent himself. And later the recommendations to do the inspections also came from the property management company. So that I think is important to consider when determining whether or not, or who may or may not have been making discriminatory assumptions about complaint that she alleges. And then last of all, I just wanted to reiterate that I don't think the rent payment increase was connected to a protected class in any way, not as far as I can tell. Happy to answer any questions.
Can you, I think it's in the record, how many units there are and who, and
Yes. So that's on page 3 of the report, in the back section. So there's 1, 2, 3, 4, 5 units. And on that page, it lists the rent for each, at the time of the report was written, the rent for each unit and kind of what each unit is made up of.
and but along that line, do you know female, male, single,
Yes.
you know, all that?
I believe that was in
That's
there.
in the report?
Well, if it was not, I intended it to be. That's not on that list, but footnote 10, yep, there it is. Yes, so for what unit is that? Unit 2F is also female resident. I think, honestly, I don't remember what the other ones are off the top of my head, but I think I would have made note of any of the other ones were female, occupied by females. Does that answer your question?
Yeah.
Okay.
Yeah, thank you.
I'm trying to understand the retaliation claim. Is there a rent increase after she makes the complaint?
The retaliation complaint, yes, was an amendment to her initial complaint that came in because there was an inspection that came up for the apartment later on during the course of the investigation. And the complainant alleged that inspection was a retaliation for her submitting this complaint. But the respondent showed that inspection had already been scheduled for this, and that was in due course with what they were doing. I believe also it was for the whole building, not just for a complaint.
I'm just puzzled by the posture of this. She's there, she's paying the rent. You're saying that your conclusion is that there's no unlawful discrimination in the rent increases. I'm not sure what the consequence is of our decision. No question.
Unfortunately, as the investigator, I can't look at the consequences. I just have to interpret the law.
Any other commissioner questions for Colin? None, thank you, Colin.
Thank you.
We've heard from the parties and the investigator. At this time, we're looking for a motion.
Can I say one more thing?
Not at this time. Okay. There are 6 proposed findings. If you would like to take them all together, I think that would be fine.
I move to accept the investigators' recommendations as written in the report.
Second.
Moved and seconded. Any discussion? Ryan.
Without not allowed to have a conversation here, I just want to say that, as I believe it was Commissioner Douglas said, we all appreciate the fact that there's a huge housing crisis in Maine. And you made the comment that we are your last hope. We are not allowed, we have no jurisdiction in rent increases. Our jurisdiction is, were you discriminated against? Did he raise your rent because you were single, a female, well, and on and on and on. And that's the only thing we can rule on.
Yes.
We have nothing, we can say nothing. If you raised it to 3,000, we can't do anything about that. That's all.
Yeah, I would second all of that. And I would just say that, these cases are painful. they're painful. It's painful to hear what you have to say, where you are and how you feel about your circumstance. But Commissioner O'Brien is 100% right. We don't have jurisdiction to modify your rent or et cetera, et cetera. And under the law, I mean, landlords they can increase the rent. The evidence in this case is that the rent is less than market value, right? I understand, but I don't think this rises to the level of discrimination case. I'm just gonna throw this out there, probably gonna get reprimanded later for saying it, but it would just be, I mean, you've been paying this rent for 2 years. It would just be wonderful if you folks could work something out so that she could stay there. I'm just gonna put that out there. Don't yell.
I'm not, no,
Don't yell.
I'm just going to ask if there's any further discussion, that's all. Any further discussion? Seeing none?
Can I say one other thing?
The case at this point is.
His dates are wrong. The incident happened 10/22.
Michigan.
Or 12/22.
The motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David.
Reluctantly, yes.
Commissioner O'Brien.
Yes.
Commissioner Douglas.
Yeah, reluctantly, yes.
Commissioner Walker.
Yes.
Commissioner Sanders.
Yes.
We want a new category of voting.
Reluctant. I would be very happy to
Let's see
implement that.
if you could strenuously object.
All right, the findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearing.
Thank you. Can I just say, there is an error in his report. The incident happened 12/22. I filed the complaint 10/23. I know, I'm going to leave, but there's an error in his report.
We are finished with this case.
Okay, thank you very much.
Next case is Housing and Employment Together, HE 240067, Joanne Syson versus Seaside Motorway. And it's a recommendation of no reasonable grounds ×2 for both claims, housing and disability. We'll hear from complainant.
Is there anybody here for complainant? Ms. Syson? Ms. Season? I'm not sure how to pronounce your name. I'm sorry.
I need to recuse myself from this matter.
Okay. If you are, Ms. Season, if you're on the phone, if you push *6, that should unmute you.
Think there is, they're all.
There's one person, that person on the end is a phone number. Let me just get her contact information in here and see. All right. I do not see her. Chelsea, can you just check the waiting room just to see if there's anybody there? Joanne. Probably here.
Or there's water over here.
So.
Colin's just checking the waiting room to make sure.
No.
Nope, okay. So, we have no complainant and this is a no reasonable grounds case. So generally we would default to the investigator's recommended findings unless anybody has questions for Angela on this case. Seeing none. Thank you, Attorney Hoffman, for being here. We're gonna go for a motion. Do I have a motion? There are 2 proposed findings.
I move that we find no reasonable grounds either on housing or disability.
Moved and seconded. Oh, hang on. Here she is.
Here she is. Attorney Hoffman was halfway to lunch.
You're almost done.
Hello?
Tyson, good timing.
Hello?
We were just about to vote on your case.
No, this is because my phone kept going out on me. That's why.
All right, well, here you are. We've called your case. You have 10 minutes whenever you're ready.
I'm ready now.
Okay, go ahead.
When I was first hired, I was hired on or about May 1st of 2018. I was hired as an overnight security position to cover the following shifts: Wednesday, Thursday, and every other Friday, Saturday, and Sunday. I would provide coverage at 9 a.m. and end at 8 a.m. I would answer the desk phone and answer the door if there's any guests needing help, such as unplugging their toilets, physically going into the room and doing whatever needed to be done to help the guests, even to the point of letting them in the building. I was provided a small apartment at that time, and I received about $100 a week before taxes. During the COVID crisis, Ken Mason wanted to get the maximum cash supplement during the state of Maine, and therefore added me to a number of paid working staff. I did start work as of July 15, 2021. And after that, after one of the long-term employees, Neil Whitehead, had retired.
Ms. Sysom, please don't use the names of third parties who are not named parties to the case. So you can use your own name and the name of the motel, but nobody else's name.
I would like to add that other desk employees that also complain about this other person who just retired, was always making mistakes and left work to finish them at their end of their shift. Ken Mason had asked me if I wanted to replace Neil and the other employees.
Please don't use the names of third parties.
I'm not using names of third parties, ma'am. You warned me once, and that's what I'm trying to do. I'm sorry. I'm trying to follow your rules. So I was left with Thursday evenings from 3 to 9 p.m. and on Saturdays from 8 to 3. I would cover on all the holidays, such as Thanksgiving and Christmas. Because I had family out of state, it was difficult to travel. And I gave the other desk people a chance to spend time with their family. It was a nice gesture. I received Christmas cards from the Mason family and the Severances. These are the people who own the property, thanking me for all I've done. And I want to note that I've also received numerous cards of thank you and credit, and even a gift card for helping some of the guests. I have never had any complaints from any of the guests, neither have any of the employees, except for Mr. Mason telling me that I had complaints for them. I would check the property for hazards, like I was supposed to be doing on my night shift, as well as making reservations. According to the attorney Hoffman's response, that Mr. Mason told her that he was seeking other legal help to try to get me to fire me at the time when I purposely fell shoveling snow at an area where I was supposed to be shoveling snow, and I fractured my bone right at the end of the wrist and required surgery. So I don't even know what he's even talking about that as far as that goes, but I do have an injury, as well as been diagnosed with severe anxiety and depression since I left the police department in Portland back in 2000. So I have a history of that, and he knew that because I told him that. And during the time working on the desk, I was bullied by another person who lives on the other side of me and shared the same responsibility as me. This other person would tell other employees and Ken Mason that I was making mistakes. I was being rude to customers, when she in fact was the one who was kind of rude to the customers when they were coming in the door, make disparaging remarks about them. She would really mess up their reservations really bad. She would have paperwork. I would go down there. She would have paperwork scattered all over the place. But she kept insisting that I was the one who had issues. And she would even tell other employees that I was having these issues and didn't know my job and making complaints about me. And when I went to Mr. Mason and would tell him that, this is what happened, I would report the night before or anything, he would say, okay. He never once came to me until there was an incident down on the beach, which Attorney Hoffman made it sound like I was, she kind of like it made it like pressure, she was pressuring me or making a threat that they were trying to get the police department to get the reports from Kennebunk Beach. And that was the only thing that, the only reason I had the police there was because I was walking my dog on the beach and I was threatened by a group of West Kennebunk girls who were out smoking and partying on the beach. And I just told them to clean up the beach. And then they threatened me. They were gonna, one of them stood face to face with me and said she was gonna punch me in the face. So because of the situation and my anxiety, I went back to the inn. And I had my dog with me, and I called the police department to file a complaint to have them go down to the beach. And then I hung up after listening to the dispatcher, she was running me a check. Apparently you can't really, they changed procedures since I've been on the police department. I never once called somebody's business or called their owner in the middle of the night and filed a complaint against them, or allegedly filed a complaint and said that this person did this and this person did that. So I feel that this is made in a false report based to me by Mr. Mason as a way to intimidate me. So I'm basically raising my anxiety level. This is somebody who Mr. Mason says he knows he has.
Ms.
I have
Tyson,
anxiety.
please stop
What?
saying Mr. Mason's name. He's not a party
He's
to this
part of
case.
this group.
You filed against the inn. You didn't file against him specifically, so he is not a named party. You can refer to him as general manager or whatever his title is, but please don't say his name.
I'm terribly sorry. As the general manager was trying to intimidate me based on my anxiety, and as well as the other employee, who he believed her more than me. So he was just raising things to the level that it was just taking a toll on me. I would be completely honest with him. I did what I was told. I did extra from what I was told. I did not purposely fall and injure my hand. He was the one, the general manager was the one who offered to take me to my surgery, physically drive me down there and pick me up, when I had also insisted that I would find, there was another woman that worked there who I was friendly with, who would take me down, and it was not a problem, but he insisted. And he made it sound like afterwards is that he did it because I was going to sue everybody, which is totally unrealistic and not true. But anyway, getting back to the police department, yes, they did come after I hung up. They were banging on my door. We're at the apartment that I lived at the inn. And I told them, and yes, I was excitable. I was having an anxiety attack. And I told them that they didn't go down there. And I told them what happened. And then they blew it out of proportion. And supposedly the general manager got a call from them in the middle of the night saying that I said that I was acting irrational and making statements that weren't true. There was somebody who was on the other side of the door that was working at the desk. She could not hear the conversation clearly. And she made suppositions to the general manager that were entirely true, that were not true. And this, again, complicated my anxiety level. Mr. Mason, the general manager, also left my personnel file wide open on his desk for several weeks. And yes, we did have access to go in there to get keys if we needed them because other guests did not return former guests would not return keys, or the guests there had lost their keys, so we had to go for duplicates. So there were some severe issues going on there as far as management. There's a lot of things that it's like poor management on his part. As far as discriminating, yes, I am one of the older people working there. I did my work. I catered to the younger ones who were working there. And like I said, my other coworker who lived on the other side of me, I've always done everything she asked. And then it got to the point where she was bullying me and creating a hostile work environment for me, which again is feeding into my anxiety and my depression. And when I went to the general manager, he would turn around and he would just say, oh, okay. And then towards the end, he said he would sit with me at the desk for like part of the shift in the morning, from like 8 until like 11:30 noontime, when he said he was taking off.
That is your 10 minutes. No, she's still there. Any commissioner questions for Ms. Dyson?
What is that? I'm sorry.
I'm asking the commissioners if they have any questions for you. Commissioner O'Brien.
Okay, thank you. Can you again bring this to a point in why you feel you were discriminated against based on age? I mean, can you do any comparative, can you do any comparison, age comparison with others? And also, did you request, it appears to me, may be wrong, that they did try to accommodate lots of things. They gave you gift cards, but did they, how do you feel, did they refuse to give you an accommodation? Did you ask for one?
I had to be accommodated because of my hand. I tried to work it out as best with my restrictions. I was still doing my duties. I had to, as far as after my surgery, and my hand still is not complete. I still have severe Parkinson-like tremors as a result of this. I had to use my shoulder to lift up the cover of the hot tub, which was part of my duties at night, to put chlorine and stuff in there. And then when I told him what I was doing, how I had to do that, he finally told me, he goes, oh no, you don't have to do that. Now this is after like a week or two goes by. Now he should have known that as a manager, general manager, owner, whatever you want to call him, that he knew that he should have been out front and forward and said, look, if there's anything that you can't do, let me know. Not until after the fact. The other thing is yes, with my age, we are all about the same age. I agree to that. However, I do not have, I did not deserve to be bullied because I was singled out for doing my work, for reporting effectively like I was supposed to. If there was any situation, I went out of my way for people.
Okay. Thank you. Sounds like you were a good employee in that respect. Again, I just hear you say that everyone is about the same age. So how were you discriminated against because of your age? Do they treat you differently because you were 59 than another?
Because of my age and because of my physical disabilities?
No, because of
with my anxiety?
You are making the claim on 2 counts. One is age discrimination. So how did they discriminate against you because of your age if you had colleagues that were the same age? What did they do? Why?
There was a younger employee there who was just out of college, and when I would ask her things, she would just shrug her shoulders and just make comments like that. She didn't care. But apparently, and I've always asked, I've had to ask her things. She would just ignore me. She wouldn't ignore anybody else, any of the other people my age. The general manager just let her have leeway with everything she wanted to do. And
okay, thank you.
It seemed like I was the one who was being singled out.
Okay, thank you.
Other commissioner questions for Ms. Dyson? Seeing none, Attorney Hoffman, you have 10 minutes.
Thank you. Executive Director Crossman, can you hear me?
I can, yes.
Okay, brilliant. Good afternoon, Commissioners. My name is Attorney Kelly Hoffman, and I represent the respondent, Seaside Motor Inn, in this case. I will not reiterate what the investigator has told you via paper and our filings. I understand that Investigator Morse is here as well. When I listened to the complainant speak in this matter, she talked about the fact that there were no complaints made by guests. Throughout the paperwork provided to the commission, there was testimony and documentary evidence supplied talking about the complaints from guests due to her explosive anger. There also was a lot of dialogue from the complainant in this case based upon the police incidents involving her. We have produced those police records in our responsive filing, and those are located at Exhibit 14. Those documents speak for themselves, and the police were called due to terrorizing and threatening. And those aren't words that I came up with. That's why the police were called. That's how they've cataloged it. She is correct that after the police were called, the general manager of the respondent received a phone call from the Kennebunk Police Department and also a visit in person. The general manager testified to Investigator Morse regarding that incident and the fact that the police came due to concerns about her anger management. To answer your question, Commissioner O'Brien, in this case, the complainant was hired when she was 59 years old. She was terminated when she was 65. Her job duties at the time that she worked there, individuals who worked with her were 74 years old and a woman in her 20s. But the woman brought on to replace the complainant after she separated from employment was the same age she was, 65 years old. As to reasonable accommodations, I believe Investigator Morse did a great job explaining to you a number of the accommodations, which included not only not having to do job duties, not only having the general manager giving her extra money and extra grocery gift cards due to the fact that she was on workers' compensation and they don't pay wages at 100%. Ms. Sison also told you about how she was driven to her medical appointments and her surgery by the general manager and others at respondent. To that point, what I did hear the complainant say to you was that she was discriminated against as to a reasonable accommodation because the general manager and others didn't come to her and say, whatever it is you need, you can get. Very simply, black letter employment law doesn't require that. It requires the employer to give or engage in an interactive dialogue, but it doesn't give the employee the carte blanche to be able to say, this is exactly what I want, and if you don't give it to me, you've engaged in discrimination against me. I'm happy to answer any other questions you have, but I don't want to take up your time. I know you're both everyone there is very busy, and I know Investigator Morse is here to answer more poignant questions as well. Thank you.
Thank you, Attorney Hoffman. Any questions for respondent? Yes, Commissioner Davis.
It appears, Attorney Hoffman, that there was accommodations in terms of the physical disability in her hand. I think she's alleging a mental disability of that she describes in her presentation as anxiety. How do you respond to that?
Candidly, Commissioner, I would respond by saying she has asserted that she has anxiety and depression. She has not produced a single medical document to support that. We have no indication that she's on medication to ameliorate any of those alleged mental health disorders. And on top of it, perhaps most importantly, sir, she has never asked for reasonable accommodation regarding any of those alleged disabilities.
I think that's the answer, that she didn't ask on that basis. And obviously you're saying she didn't support it in any other documentation, right?
Right. And I would go one step further based upon the evidence before you that she has claimed that this is anxiety and depression. But I don't think the police department coming out with not once, but twice for terrorizing and threatening and complaints made by coworkers and guests at the hotel regarding anger management and explosive anger were the words that they used, can be put forward without documentation by a doctor explaining that that is anxiety and depression, and how exactly.
Got it. Thank you. I got it. Cool.
Any other questions for respondents council? Seeing none. We've heard from the parties. Ms. Sison used her 10 minutes, so we won't hear from the parties again at this time. We will hear from Investigator Morse.
Hello, I'm Angela Morse. I'm the investigator who is assigned to this case. I don't really think I have much to add that I didn't contain in my report, but I'm certainly willing to answer any questions from the commissioners.
Questions for Angela? Seeing none, thank you, Angela. We've heard from the parties and the investigator. At this time, we're looking for a motion. There are 2 proposed findings.
Excuse me, I'm sorry, but can I do I don't know where she got the police report.
Ms. Sison,
I don't have a police.
Ms. Sison, we're going to mute you now. You have used your time. We are moving on to a motion and a vote on your case.
I'll move to take them together and find that there are no reasonable grounds to believe the respondent discriminated on the basis of age or disability, and the accompanying no reasonable grounds to believe it was housing discrimination. Second.
Okay, it's been moved and seconded. Any discussion? Seeing none, the motion is to find no reasonable grounds. If you're in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien? Yes. Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
So the findings are no reasonable grounds. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results of the hearing.
Sure, one question. Just one. Why was this written this way?
The addendum, HUD, HUD requires us to include a summary of everything that happened in the housing case. It stays confidential if the investigator reporters have requested, because it includes the investigator's notes. Okay. That's why you have those at the end of your housing cases.
Thank you. I'm gonna keep this
All right.
all day long. All day long, I eat. I mean, no disrespect.
No, it's fine. Like Amy also used to do that, so we have somebody else who does that now. It's very, yeah, no.
I know she had food left, which is unusual. So
What's that?
So that you're gonna eat that.
Yes, I
Yes, yeah. Either now or on the drive.
Oh, yeah.
All right.
Moving right along, the next case is the housing case H240083, A, B, and C. Alan Corriveau versus Elderly Housing et al. It is a recommendation of no reasonable grounds. We'll hear from complainant.
Is there someone here for Mr. Corriveau, or Mr. Corriveau, are you here? If you're on the phone, push *6 to unmute yourself.
Do we know he's here, or is that the K?
I
or-
just, no, that is the person for the next hearing.
Oh, that's right.
There's no, right. We have one person on the phone with a 347 area code. Are you here for this case or for the next one? If you could unmute yourself by pushing *6. Hi.
I'm not there for this case, for the next one. Thank you.
What's your name?
My name is Lisa DeMasso.
Okay. Thank you very much.
You're welcome.
Complainant is not here. As we just discussed in this case, when the complainant is not here and the recommended finding is no reasonable grounds, generally we default to the investigator's recommended findings, unless you have any questions for Angela about this case. Seeing none, thank you, Angela, and thank you, Attorney Silver, for being here. At this time, we would be looking for a motion. There is one proposed finding.
I move that we accept the investigator's report that there are no reasonable grounds that discrimination occurred.
Second.
So moved and seconded, any discussion? None, the motion is to find no reasonable grounds. If you are in agreement, you will vote yes. Commissioner David?
Yes.
Commissioner O'Brien?
Yes.
Commissioner Walker?
Yes.
Commissioner Douglas?
Yes.
Commissioner Sanders?
Yes.
Okay, findings are no reasonable grounds. We appreciate Attorney Silver being here, and Angela, and the commission will send a letter confirming the results of the hearing. I'm going to be saying that last phrase in my sleep.
Last case is a housing case H 24-0110, A, B, and C, Kodishi Dawanko versus Poulin et al. It's a recommendation of no reasonable grounds against all respondents. We'll hear from complainant.
Thank you. Thank you. My name is Jack Baldacci. I represent the complainant, Kodishi Nwanko. I don't want to rehash too much our prior submissions, so I would refer the commissioners to our prior submissions that we've made in this matter. I would note briefly, we do not dispute the investigator's finding that Ms. Nwanko was treated differently than non-African American tenants. When the respondents posted a late rent notice on her door, failed to offer her a one-bedroom apartment, demanded payment for letting her into the apartment after hours, and did not notify her or knock on her door, take additional steps to notify her about an impending flood. We strongly object to the finding that the claim regarding the late rent notice is untimely. I believe we pointed out that under the Havens Realty Corp. V. Coleman case, under the continuing violation doctrine, if my client asserts a violation of the Fair Housing Act, it's considered to be a continuing violation doctrine, so long as one of the violations is within the statute of limitations or the time period for filing a complaint. Respectfully, in this case, we've demonstrated multiple instances of alleged discrimination that occurred within the relevant time period, so that the claim regarding the late rent notice is timely and should have been considered in the case. We just further point out that the notice was posted on Ms. Nwanko's door shortly after she informed respondents that she's going to be late on her rent. And respondents did not indicate via email that he would be putting a public posting on her door. This was initially denied by respondents. I believe they indicated in the beginning that the notice was just folded and pushed through her door, or words to that effect. This was proven to be false, respectfully, when an email correspondence showed the respondents admitted to posting the notice on the door. It was infuriating and humiliating for Ms. Nwanko because she had just notified respondents that she was going to be late on rent, and no other non-African American tenants had late rent notices posted on their doors. Other tenants confirmed they were late on rent and did not receive such notices. Moreover, Ms. Nwanko indicated that she confronted Mr. Pullen and said, I believe this is a quote, "You do not give a damn for me because I am a Black person. What have I ever done to you?" So we would submit here there's a pattern, again, respectfully, of discrimination in this case on behalf of the respondents against my client. And we would object to the investigator's report that respondents have demonstrated legitimate, non-discriminatory reasons for their conduct, or that the stated reasons are pretextual, excuse me. We would point out with respect to Ms. Nowenko being charged $25 to be paid personally to the property manager. There was no evidence of any such policy that the respondents produced. The respondents haven't been able to demonstrate or provide proof that this was charged to any other non-African American tenant. Indeed, there was a recorded conversation, an emotional conversation between Mr. Jakes and Ms. Nowenko, where Ms. Nowenko raised the similar concerns underlying her complaint. And Mr. Jakes indicated words to the effect of, if I were in your shoes, I probably would not be handling this as well as you are. It's hard to hear this. We cannot get better if I do not know how people are thinking and feeling. Quote, I cannot defend any of this. I cannot believe you are not more angry. I'm emotional listening to your story. It's hard to imagine why people can feel that way. It was clear the conversation was about Ms. Nowenko feeling that she was being racially discriminated against by the respondents. And again, with respect to the $25 fee, there's a pattern in this case where Ms. Nowenko, as the investigator found, is treated differently than non-African American tenants. And the question is, why? We would respectfully submit that based on the evidence in the case, it's because Ms. Nowenko is an African American. There's really no other, there was an animus on behalf of respondents, and there was no other, reasonable basis or legitimate basis why she would be treated differently than other tenants. Just finally, Ms. Nowenko's email correspondence that's been previously submitted in her May 2nd submission indicated that she had requested on no less than 4 occasions to rent a new apartment. And it was only after she verbally confronted Mr. Pullen that she was given the opportunity to rent an apartment with the respondents or to upgrade. Finally, the last example cited was there was a storm in December of 2023, a significant storm. Mr. Pullen had sent an email prior to the storm notifying the tenants that they should move their cars and also telling them where they would be safe or not safe. Ms. Nowenko later on in the day confirmed with Mr. Pullen where her car would be safe. When the respondents realized the storm was bigger than they anticipated, they knocked on tenants' doors. They notified tenants that they needed to move their vehicles. I believe they in fact moved some tenants' vehicles for them. Ms. Nowenko didn't get a knock on her door. She suffered a complete loss of her vehicle or property in the vehicle. And again, going back to the pattern in this case, question is why Ms. Nowenko got treated differently than any other tenants. For those reasons, we'd respectfully request the commission find reasonable grounds for discrimination. Thank you.
Great. Any commissioner questions for Attorney Baldacci? Commissioner O'Brien and then Commissioner Douglas.
Hi, Gab.
Hi there.
You lived across the street, didn't you?
Long time ago.
I know. I'm looking at the investigator's report. And there are 2 things that jump out at me. One is that the picture of the door that was supposedly that there was a picture taken of the door of Ms. Nowenko's door, of her door with the taped notice. However, it was alleged that that was not her door, and as a photo was submitted of her actual door. That was one thing. And the other thing is about upgrading her apartment that she was at, that she says she was repeatedly asking for an upgrade and was not offered one. whereas others were. And then when then it appears there were 2 times that she was offered one and declined. Could you speak to that?
Sure, Commissioner. I would direct the commission, I believe it was Exhibit 1 to, I believe it was our June 20th submission. I don't have the.
I'll just let you know now that the commissioners don't have those exhibits. What they have is the report and your submission of disagreement.
Understood. Thank you. So we would, with respect to the door, I remember the allegation, it wasn't her door. So I would say that's immaterial because there was an email submitted that showed the property manager indicating, I'm looking at the email now, excuse me. This is a standard form letter. Ms. Nowenko was upset when she received the rent notice that was posted publicly. So she sent an email saying, is this the policy of your cooperation to post the balance on the door in hopes to humiliate your resident? Is this what you do for all your residents who are late, or is it just me? Mr. Pullen responded, this is a standard form letter. We post on the doors of residents who have not paid rent and have already received emails regarding that. Rent payments are due on the 1st of the month. And I believe my client was, with respect to your questions about her being offered, an apartment upgrade later on, I believe she was offered an alternative apartment. My understanding is at this time, given the relationship with the property manager, with respondents, she was thinking, this is not going to be where I'm going to want to stay. I'm not treated well here. She thought obviously she was being discriminated against. I don't think she wanted to live there any longer.
Can I follow up? I'm going to follow up.
Yes, go for it.
I respectfully, I believe that the door issue is important because it speaks to credibility. The investigator needed to make a decision on who was more credible in that situation. So number one, and number two, it I believe states that she was offered one in November of 22 and declined. Then again, so that was, she continued to stay there, and then offered another one in January of 24 and refused it.
Yes. So with respect to the late rent notices, our position is there's an admission on record that it was sent. And so I've heard the objection about the door. I haven't really looked into that candidly further, just because I believe they've admitted that it was posted. And with respect to her moving out, I think the offer for her, or excuse me, with respect to her getting an upgrade, I think the offer came shortly after this fall or, late fall 2022, posting about her door. She demanded, why aren't you showing me, why are you posting this on my door, and why haven't I been offered new apartments when other people are moving in? I believe they did offer her an apartment after that. I can see there's a gap between when she moved out. Again, my understanding is, she wanted to stay there. She was going to look for alternative housing, but it's, hard to find alternative housing. But I think it was in her mind after, this initial exchange that she was not going to be really here for the long term. And certainly by December of 23 or, the 2024, I believe she had already begun to make plans to move out.
Thank you.
Can I add something?
Not at this time. This is the opportunity for your representative is here to speak on your behalf. Unless the commissioners would like to. We can be a little flexible about this.
I would actually like to hear what you
Go
have to
ahead,
say.
sure.
Yes, please.
We're flexing all the procedures today. It's great.
And I thank you so much for that. With regards to the note on the door, as soon as I got home, I took it off immediately because it was extremely embarrassing. I had no mind to sue or anything. I was just really emotional and I came home and I took it right off. And I was so angry that I then pasted it in my home. So you would see like a white wall, and I took a photo of it, and then I went downstairs to the office and I wrote a note on it. I said, "How dare you humiliate me?" And I threw it under his door. So I took it off. The doors are oak. The color of the door at the apartment is oak. But as soon as I got home, at first, when I actually came home, I saw some residents speaking and I didn't know why. So when I got home, I couldn't believe it. I just immediately snatched it off the door. And okay, and then so the next thing I wanted to add with regards to the apartment being offered to me, I want to add that there is in fact an apartment that was offered to a neighbor, a one-bedroom apartment that wasn't offered to me. So when I first moved in, I moved in a studio apartment with hopes to move in a one-bedroom. It was essentially like a policy for the building itself. I didn't know anything about this policy until I was looking for a place to live. And they said, just take the studio apartment. The way it's done is essentially that the people who live in the apartment complex have first dibs, I guess, when it comes to if an apartment opens up. I noticed a few people moving in the apartment, and I've always spoke with Rick, Mr. Pulling, just telling him, hey, I'm interested. He never actually gave me the opportunity. I did see one tenant. There is, in fact, a tenant that moved in, and I believe it's 407. And that apartment is a one-bedroom. I was not given the opportunity to move in. The only time with regards to the first time I was offered the apartment in November was after I made the complaint that's in the email saying, if it's truly the policy that you're posting things on my door, since you want to follow policy so much, how come you didn't follow the policy to offer me an apartment? That's when an apartment became available. The second time apartments became available was after the emotional conversation at the very end of my 2-year stay. After the emotional conversation, I was telling the owner of the building, hey, I asked for a one-bedroom apartment for so long, and I never was offered. And he told me I would make it right with you and I will find a favorable apartment and I'll offer it to you. Shortly thereafter, he offered it. But this is after now I'm moving out, if that makes sense. So I wasn't offered an apartment. There is at least they admit it. There is at least one occasion that they admit that they gave an apartment to someone else without even offering it to me. There's at least that one admittance. But what I would have loved the investigator to do was to find out how many people have actually moved in within the time that I've been asking and the time that I was finally offered because I made it in writing. And then we can really see how I was overlooked. But that was not something that was forthcoming. But again,
Ms. Monco, I'm gonna stop you there just because your attorney has already had time to present and I don't want to turn this into a second presentation. Any other questions for Attorney Baldacci or Ms. Monco? Commissioner Douglas.
Yes, not sure who's answering at this point, but I'll forge ahead. So my understanding is you're alleging a pattern of discrimination, right? And Commissioner O'Brien has addressed some of these things. I just thought I'd sort of mop up a little bit. The after hours fee, the $25, right? I mean, the representation by respondent is that this was some sort of policy, right? It was a holdover from the previous owners, and now they've sort of continued the policy in a different form where the $25 is paid to the company, not the individual. Tell me what I'm missing here.
Yes, Commissioner. So my understanding is Ms. Noanko was locked out of her apartment. She requested the property manager let her back in. Property manager said, I'm only letting you back in, essentially, if I get a check for $25. She made it out to the company, and he said, no, this is going to be personally to me. This was the subject of a recorded. I understand the respondent's formal position is that this was a holdover policy. That flies in the face of what Mr. Jakes indicated during the recorded conversation, where he indicated, no, that's not our policy. Now the position is, oh, that was an old policy, and we've now modified it so that $25 gets paid to the company. They also, I believe, indicated that they could find no instances within the last year where any other tenant was charged this $25 fee. The question again is, why was Ms. Noenko, why did she get the notice on the door? Why did she get the $25 fee? And if this was a policy, why is no one else getting charged for it?
Right, and so I think that what the operations manager said was that it was not policy to request personal payment, right? It's a slight nuance there, isn't there?
I believe the record will show that he indicated that's not their policy. The distinction between personal and company, I believe that the company after this case has indicated we're now changing policy so that $25 gets paid to the company. So I didn't understand. It would be news to me that's in the record.
Okay, and then the business about the flood, right? So I certainly understand your client's position. From her perspective, the property manager's running around knocking on doors, moving everybody else's car, whatever people need, right? And she's just sitting in her apartment being ignored. But there is also an allegation of an email. And I'm just wondering, do you guys dispute that the email actually was circulated? And that she received it?
Oh, sorry, Commissioner, I didn't mean to interrupt.
That's all right. The Zoom thing is tricky. Yeah.
Yeah, we don't dispute that an email was sent. I believe it was sent by Mr. Pullen the morning of the storm, essentially saying, we're going to have a storm. We don't think it'll flood the parking garage. Your vehicles will be safe in the upper portions of the parking lot. It then became clear, I believe this was a significant historic storm, that this was going to be a bad, worse than they had expected. Our dispute is Ms. Noenko came home. She was a reporter. She came home from work and asked Mr. Pullen, my vehicle's parked. I don't know if it was in the upper parking lot, but she said, my vehicle's parked here. She pointed to it. She said, will it be safe here? He said, yes. When respondents realized that this was going to be worse than they expected, then they started notifying tenants. I don't believe it's any subsequent email. So the concern is about the subsequent notification. The respondents learned it was going to be worse than they anticipated. They call or knocked on doors, notified other tenants, but they didn't notify my client. That's our concern about that incident.
That's actually helpful, thank you. And then just to go back to the business about the new units and follow up on Commissioner O'Brien's questions, I just want to make sure I understand this, right? So, there's one instance I think we all agree where she's not offered an apartment and maybe she should be, a 1-bedroom, right? And then I think your client explained the situation in January 2024. I guess I'm still wondering about the situation in November of 22 when, allegedly she's offered a 1-bedroom and declined. And if that's already been explained, I apologize. It went right over my head, but
no.
Can you address that for us?
Yes, Commissioner. My understanding is that this offer only came after after Ms. Noenko confronted Mr. Pullen as being racist, and then an apartment was offered to her. My understanding, and I know this is a little unorthodox, but I invite my client to correct me, is that by this time she had felt that Mr. Pullen was discriminating against her, respondents were discriminating against her, and they were only offering this apartment to her in October of 2022 because she confronted them as being racist. I believe at that time she said, I'm not going to be here longer term, but it was hard to get alternative housing, and that's why there was delay. I believe she has moved out as of, I believe, May of this year. But there was a significant time lapse from November of 2022 until when she moved out, but that's my understanding, Commissioner.
All right, so just to wrap it up in a nice neat little ball, right? Your client confronts management and says, you people are racist, right? At that point, they say, oh, whoa, we'll offer you an apartment, right? And she basically thinks to herself, but you guys are racist, so no, I don't want the apartment now. Do I have that right?
Exactly, Commissioner.
All right. Okay, thank you.
Commissioner Sanders.
Yeah, just one quick follow-up on that question, Attorney Baldacci. The timeline that's laid out here and in follow-up to Commissioner Douglas's question, it appears that the evidence that your client based the conclusion on, right? So her conclusion was that the property manager and the entity was engaged in a discriminatory practice. It appears from the timeline that that conclusion was based upon the posting of the late rent notice to the door, right? It appears that that's the only conduct that precedes her denial of the apartment that was offered to her in November of 22. Is that timeline, is that characterization of the timeline correct?
I believe that's really the first flashpoint, I would call it. I believe it occurred. I would note that I think Ms. Nowenko and Mr. Pullen would see each other, and they just didn't like each other, and I think that this was the first time where it hit a breaking point, so to say. So I believe it was this event. It was I believe in 2023, the summertime of 2023, when Ms. Nowenko needed to be let back into her apartment, that it came up again.
Sure, but so my question though was focused on the November 2022 when she declined the offer of the one-bedroom apartment. It looks like there had been one incident prior to that, which was the tagging of the notice on the door that caused your client to arrive at the conclusion that the company was engaged in discriminatory practices. That's what we've got in the record, or excuse me, in the investigator's report. So perhaps it's a better question for investigator Brendan, but if you'd like a crack at answering that question, happy to have you do that too.
Sure. I believe, what I would say on that, Commissioner, is that I believe my client had been requesting to get an upgrade for a period of time. And that's demonstrated by her emails after the notice was placed on her door. So I think she was frustrated and feeling like she was being discriminated against because she wasn't being offered a one-bedroom apartment. And then she notifies the property manager that she's going to be late. A few days later, the notice is posted, and then she confronts him. So I believe in terms of a timeline, that's what took place to start. And then we have the subsequent series of events leading up to the flood in December of 2023. That I hope that answers your question.
It does. Yeah, it does. Thank you very much. Appreciate it.
Any other questions for Attorney Baldacci? Seeing none, Attorney Baldacci, you'll have about 3 minutes when we come back to you. Attorney Stoughton? Get up here without tripping.
Yeah, thanks everybody. And everybody over here. I represent North River Hathaway. We own the building in Waterville that we're talking about, and you probably understand it's a mixed-use building with apartments, rental apartments on 2 of the floors. Some of those are residential units that Ms. Nowenko could rent. Some of them are reserved for corporate tenants. So in our view, we were confronted in this complaint with 4 different incidents where Ms. Nowenko says, look, you guys discriminated against me. And we looked at each one of them, and there's a reason for what my client did in each of those circumstances. just because there've been a lot of questions asked about the timeline, I'll kind of just go back to say, she moved into this building in January of 2022. She first requested to move in before that in 21. We didn't have apartments available. This is a building that usually, I think I'm talking too fast. This is a building that usually has a waiting list. So she moved in January 2022. She moved out this year in early 2024 in March at her own, that was her own choice. When she moved in, before she moved in, she was offered one of the furnished apartments that North River Hathaway had available. She declined that, which is fine, and it might have been because those cost more because they're furnished, her choice. So she was offered a studio, which she took, and that's where she lived until she left. So let me kind of go back and move forward on the timeline. So the first instance that she's talked about is this November of the notice posting in November of 2022, and the investigator found that that was outside of the 300 days, and that obviously it is outside of that. Regarding, and I don't think it matters either way, because it is clear it was clear, I think, from the submissions and from what I've told and we've told the commission and to Attorney Baldacci and his client, that our client didn't discriminate against Ms. Nwanko in any way, either on that or the other events that happened. They have had different policies during the time that this owner has owned the building. And for a time, they did in fact post notices on the door. They changed that before this ever happened to being folded. When we were given this complaint, they didn't keep records except in the case of evictions. So we don't know, we couldn't tell you this one was posted or that one was posted. We did produce to the investigator other notices to other tenants in a different time period. The building would have treated all of the people, all of the tenants in the same time frame the same way, okay? So at one point it was the policy to post overdue rentals on the doors. They changed that policy, not because of Mr. Wango or this complaint, it was changed before. And when we responded, we originally thought that it was not posted. She says it was. There's an email that was produced. And what I will say is that the picture we have is not the door. But there is this email, and Attorney Baldacci is right about that. But whatever we did at the time frame, we did for everybody else. Unfortunately, the company didn't keep track of which got posted on the door. They just have copies of the notices, which we've produced, but I can't tell you this one was put on the door, this one was not. At this point, the only time the company posts any kinds of overdue notices on the door, as my understanding is when they're advised to do that by legal counsel, usually in the context of an eviction procedure. So this happens in October of 22. Ms. Nwanko brings it to Mr. Pullen's attention. He is named. Okay, so I'm trying to keep track here. And at the same time, there are discussions in those emails about, hey, I wanted a 1-bedroom apartment. So now I'm going to shift gears to the 1-bedroom apartment, which is, I'll call it the second of the claims raised. So in those emails, and it's probably not, I don't think it is in the investigator's report, but Ms. Nwanko points to 2 other apartments on her floor. And she says, well, look, I've been asking for 1-bedroom apartment. How come you're not giving me an 1-bedroom apartment? These other 2 units, and I think they're 445 and 405 and 444. I saw people move into these. Why wasn't I offered a unit? So because she raised the issue with 2 apartments that she was looking at, we were able to look back and say, okay, well, one of those apartments, 444, is actually rented to the college. So the building doesn't rent out that unit. The college chooses who they're going to live there. We understand they just let employees use it for periods of time. The other unit was a very special circumstance. It's confidential, not to the people that are involved in this. It did have to do with a safety issue, and we provided that information to the investigator and to Attorney Baldacci and his client kind of off the record because somebody else's interests are involved. But we know why those 2 units were rented to somebody else and not offered to Ms. Nwanko, and she now knows too. Today she brought up unit 407. That was never, that's the first time I've heard about that unit, so I have no answer for that, but I will tell you it's not in the record because it's not a number that she was ever given to us. So she requested a 1-bedroom unit. At the time, those arrangements by the building were pretty informal. They put your name on a list. It might have ended up like on a Post-it note on the manager's desk. And they tried to give people the options of moving when those units became available. We've changed that, not the policy, but now we're very much more formal about it so that everybody knows and that the process is very transparent. But what we know is she was offered a 1-bedroom before she moved in, she declined. She was offered a 1-bedroom again in November of 2022. She declined. And at that point, there really wouldn't have been any reason for the building to keep offering her apartments. Now we've got a form that says, okay, you're a tenant. This is what you want. This is the date you make the request. This is the action that was taken, and it makes it clear on the bottom that once you decline that request, you won't be considered unless you submit a new request. So now we have, the policy hasn't changed, but it's more formal, and now we have a form so that we would always know we'd be able to go if somebody asked, well, how come you didn't offer me a 1-bedroom apartment? We have a form right there that we could look at and talk to about it. And then she was also offered, as you've already talked about, she was also offered a 1-bedroom unit again in January 2024 and declined that. So there's nothing discriminatory about any of that. It was just, this is what's available. This is what you requested. This is what we know about your request. The other two things are the $25 lockout fee and the storm. Talking about the lockout fee first, that was apparently in May of 2023. I'm not sure who has said what at this juncture, but somebody said that was a holdover. That is in fact true. The property manager that currently manages the building also managed it for prior owners. He's been there quite a while. The prior owner's policy was that if somebody had to come back and unlock an apartment as opposed to get you in the building after hours, there was a $25 fee charged, and that was paid directly to the manager who had to come back. Okay. That information was not tracked. The manager does remember at least one occasion. He remembers specifically an occasion with one particular tenant, which happened a couple of years, he thinks, before Mr. Wanko's, and the same procedure happened. He got a call after hours, had to go back, let that person in, he received $25. The building still has the policy of charging in that instance, but now it gets paid to the building. It goes on the tenant sheet so we can tell exactly what is paid, and then the building takes care of compensating the manager who had to come in. There are a couple of other situations, I don't know if anybody cares, but if you lock yourself out of the building, we have a different situation for that with the lockbox. The manager doesn't have to come in. During the day, if somebody locks themselves out of their apartment, manager's right on site. So nobody gets charged a fee, nobody has to do anything, still don't keep any records, but if it happens, they just take care of it that way. So that's the $25 fee. Same for everybody. Same now, only in a very specific circumstance. It just doesn't happen very often, as I'm told. People don't do it very often. They're more likely to go out and walk their dog and lock themselves out of the apartment building. So we've figured out a way to do that. The storm, that's December of 2023. It's a 100-year storm. Everybody's trying to figure things out. We get it. We sent the notice. Everybody agrees. Well, Ms. Noanko agrees she got that in the morning. It's a fast tracking event. Everybody's trying to do what they can. Unfortunately, not only Ms. Noanko, but at least 6 other tenants in the building ended up having their cars flooded because of the way the flooding worked. So we didn't treat Ms. Noanko any differently. We understand the manager did knock on doors. He knocked on whoever's was around, and I'm going to get cut off.
That was your time. Okay, thank you. Any questions for Attorney Stouter? Commissioner Douglas?
Yes, good afternoon. So you heard the complainant say that with respect to the 1-bedroom in 2022, right? She basically told property manager, whoever it was, that they were racist. At that point, they're like, oh, we got an apartment for you, right? And I just wanted to Because I didn't hear that in your recitation. I want to see if you got a response to that allegation.
There's no question from the email that Ms. Wanko produced that she gave Mr. Pullen kind of an angry email and said, why didn't you do this? He does not remember being called racist, nor does that email call him racist, but he does, she did bring up the one bedroom apartment, and so he said, okay, talk to the operations manager, and then they offered to one.
Right, and then the business about the flood, right?
Yeah.
So I guess the allegation is, there's the email that goes out in the morning, everybody agrees on that, right? The situation is changing, as you say, and then here's the property manager sort of running around, knocking on doors, moving other people's cars. She alleges that she sort of left over here unattended to. And I just wanted to, I credit your statement that 6 other cars were flooded. I'm just wondering what's your response to that? That she's basically being left out of this sort of process as it moves forward and things get more urgent.
She wasn't left out of the process. The manager was knocking on doors late in the afternoon before he left to let his own dog out and go get something to eat, come back. I think he said that to the investigator, but anyway, the manager was knocking on doors in the late afternoon. We don't actually think Ms. Noack was there. We think she was working, but by the morning, the flooding had occurred, so there wouldn't have been any reason to be knocking on doors in the morning. Manager says, I didn't leave anybody out. I don't think that there's any information. I certainly don't have anywhere. I'm not sure where it came from that people are talking about our folks moving other people's cars. What I know is in the record is that in May, again, timeline issues, but in May, not this storm, but a prior storm, Ms. Noango had asked Mr. Pullen to move her car, which he had done. He moved her car, but that was a different storm. So the evidence is that he moved her car in a different storm, and presumably would have done the same for this. I don't have any information. I don't think there's any in the record that they were moving other people's cars. But for whatever reason, they were trying to tell everybody what they knew as they knew it. And everybody was, trying to do the best in a hard situation. Ms. Nguyen was a reporter, as she's already told you. So she would have been having information about the storm probably better than what we had, for the people that were running the building. Does that answer your question?
It does. Thank you.
Questions for Attorney Snow? Thank you.
Do you want me to stand here while you ask, or just go ahead?
Okay, go ahead and sit down. Attorney Baldacci, you have 3 minutes and 3 seconds. If there is anything else you would like to add.
Sure. Just briefly, I do believe we would dispute the timeline of events with respect to the flood. I believe there was evidence in the record that the respondents knocked on doors, and I believe also moved cars for others. They noted that there was 6 other individuals that suffered losses, I believe, is what they stated as a result of the flood. Again, our questions would be, were those tenants notified? Ms. Noanko was in the building at the time. So just, to paint the scene, she was in her apartment, other doors were getting knocked on and tenants were notified. She was scheduled for work and texting her work that she had been up all night. She also had a dog who, was very temperamental. So if someone knocked on the door, she's going to be aware of it. She never got a knock on her door. And the question again is why is Ms. Noanko treated differently? And that's with respect to all these occurrences. The respondents indicate they didn't have adequate records, or, the company policies have changed. We understand that's their proffered reason for why Ms. Noanko was treated differently here, but we would respectfully submit that that's clearly pretext in this case. It's not a legitimate reason for why, Ms. Noanko is getting notices published on her door, why Ms. Noanko is getting charged a $25 fee. I don't believe we've seen any evidence of anyone else getting a $25 fee. I believe Attorney Stouter, my colleague, said that it was the prior owner's practice. So the entity that bought this building before is the allegation that they had this policy, and Mr. Pullen was simply following their policy. They haven't produced any records showing that. There's no written policy to that effect. So we would state that that's pretext and that there's been discrimination in this case against my client. Again, for those reasons, we respectfully request the commission find reasonable grounds for discrimination. Thank you.
Any other questions for Attorney Baldacci? Seeing none, thank you both. We've heard from the parties and the investigator. We have not heard from the investigator. Long day. Almost there. Seeing none, thank you both. Next, we will hear from Alex Brindley, who was the investigator assigned to this case.
I sure was. Thanks, Kit. So I just want to quickly go over all the claims because I feel like there's like a difference in understanding of what happened in these 4 instances, but based on the evidence that was provided to me, these are going to be my conclusions. So in regard to the late rent notice, the respondent provided that this was in fact procedure, which respondent attorney mentioned. I also, in regards to that late rent notice, the complainant indicated that she hadn't seen any other individuals receive a late notice. During my IRC in my conference, I asked when a late notice would be posted to the door, and that would be specifically after the 15-day grace period. So that could explain why the complainant in this instance hadn't seen any other late rent notices in the past, because while other tenants had been late with rent, the respondent stated that none had exceeded that 15-day grace period and therefore did not have this late notice posted on their door. Furthermore, it's the second one. So in regards to the request for the 1-bedroom apartment, again, it seemed to me that the procedure was you ask, it gets offered to you. In my final RFI to the parties, I asked the complainant to provide any communications where she requested a 1-bedroom apartment, and only one was provided. That was the original email that Attorney Baldacci had referenced, October 19th. And shortly thereafter, the respondents offered her a 1-bedroom apartment, which she then declined. And I think it seems reasonable that once you decline a 1-bedroom apartment, kind of makes sense that they wouldn't continue to offer a 1-bedroom apartment to the complainant. In regards to the after hours entry, like it stated in the report, this was a procedure held over from the previous management. In the referenced recorded conversation between complainant and the operations manager, the operations manager said it wasn't procedure to pay the property manager directly. So in that case, it was procedure to charge a fee for late entry, after hours entry, but just not to the property manager himself. I believe that had been changed at that time to, or if not, shortly thereafter, to pay the company for that late charge. Attorney Baldacci was referencing, or he made comments of the fact that no other tenant had to pay this late fee. That's because no other tenant needed to be let in after hours. And in regards to the flood, all tenants were notified of the flood via the email that has been referenced today. When the complainant mentioned that she got home from work the day of the flood, she ran into the property manager, they spoke. She asked if her car would be safe there. He assumed yes. She parked her car there. That was kind of the end of it. I do have my notes from the conference here, where I asked Mr. Pullen, the property manager, what had happened for the knocking on the door. So he indicated that he knocked on the door the day after the flood. So that would be the 19th. So he was going around notifying people that the flood had happened, so the damage had already been done at that point. And it didn't seem to me that Miss Nguyen-Quo was left out in any manner because of her race or otherwise. I think that's it. Please let me know if you have any other questions or need more clarification.
Any questions for Investigator Brindley? Commissioner Douglas?
Yeah, good afternoon.
Hi.
I was gonna ask you about the policy findings that you made. And if I'm misunderstanding what you said, please correct me, but
Sure.
I think what I'm hearing from you is that the putting the rent notice on the door was pursuant to some sort of policy, and the $25 after hours fee was pursuant to some sort of policy. And I just wondered if you could just sort of fill us in on what evidence there was in your investigation that these are in fact policy, like these were existing policy. Like, was there something in writing? Was it just somebody telling you this, or what was the evidence?
Sure. So Attorney Stouter did provide copies of other late rent notices. Their pictures weren't taken of how they were provided, presumably posted on the door. But, you know, as stated in my report, the late rent notice was untimely. It was outside of that 300-day limitation. I mention it now because we were talking about it. Yeah. And for the $25 procedure, there was nothing written down. It seemed to me that it was just a holdover.
Okay. All right, thank you.
Any other questions for Investigator Brindley? Seeing none. Now, thank you, Alex. We have heard from the parties and the investigator. At this time, we are looking for a motion. There are 3 items.
Okay, I don't want to be here. I would move that we adopt the investigator's report.
Second. Moved and seconded. Any discussion?
I think that the pattern alleged in this case is troubling. I do. And I fully credit the testimony that there are policies in place that explain at least some of this behavior. And I understand that respondent has explanations, alternate explanations as to how this all went down. But the pattern here is troubling. So my comments there.
Other discussion? Seeing none, the motion is to find no reasonable grounds on all 3 recommended findings. If you are in agreement, you will vote yes. Commissioner David?
No.
Commissioner O'Brien?
Yes.
Commissioner Douglas?
No.
Commissioner Walker?
No.
Commissioner Sanders?
No.
Okay. The findings are reasonable grounds on all 3 recommended findings. We appreciate everyone's participation, and the commission will send a letter to the parties and council confirming the results and informing you of next steps.
Kit,
Yes.
I think we should have them vote since it's a reasonable grounds finding.
Typically, you flip the vote around.
Yeah, she wants another
Now
vote.
you-
Okay, great, go ahead.
So we need another motion.
I mean-
Yeah,
Yeah, I'll move that we find that there are reasonable grounds on all three counts.
Okay,
second.
hang on.
Yeah.
Okay, so if you are in agreement, you will vote yes. The motion is to find reasonable grounds on all three counts. Commissioner David,
Yes.
Commissioner O'Brien,
No.
Commissioner Douglas.
Yes.
Commissioner Walker,
Yes.
Commissioner Sanders.
Yes.
Okay, so findings are reasonable grounds. We appreciate everyone's participation. The commission will send a letter to the parties and the council confirming the results of the hearing. That ends the hearing agenda for today. Well done, you all. That was a marathon.
Yes, it was.
All right, and Chelsea, if you want to just mute us and turn off the camera.
Yep, okay.
Actually have.
Great. Can I get a vote to go into executive session? As I was muted, we're going into executive session per unanimous vote.
Okay. Barbara, can you hear us still?
And that I could hear you but not talk to you because I was muted. Y'all know you're muted.
Colin muted us accidentally. Okay.
There.
So,
I didn't care that I heard. I just thought if we're streaming this, somebody should be able to hear you all.
so motion to litigate H 230404, H 230461, and not to litigate PA 220098.
So moved.
So moved.
Great.
Second.
Second, Commissioner David.
Yes.
Commissioner O'Brien. Yes. Commissioner Douglas.
Yes.
Commissioner Walker.
Yes.
Commissioner Sanders.
Yes.
Everybody go home. Champs, thank you so much.
Thank you. Thank you.
We'll see you back here in September for the same thing. Sorry, guys. It's gonna be another one.
I like the new,
I'm gonna
I
go
like
back
the
and
new
watch
do,
the
Barbara.
in September.
What?
I like the new do.
In September.